There is only one matter which is pending against me as on date, my lord. And my lords may kindly also note the matter in which my lords may also note the matter in which my lords may grant me interim bail also.
We have granted you, ma'am.
I'm so grateful, my lord.
You know why we have granted you?
Please, my lord.
We'll tell you why we have granted you.
Please.
And if you don't grant bail, the moment you are arrested, you will be brutally, you'll get a great reception out there.
Red carpet reception in the police station.
I'm so grateful, my lord.
14, I beg to appear for the petitioner. I am not in jail, my lords. High Court thinks I am in jail. My learned friend was there. The affidavit was signed outside. And the entire analysis would have been different if I was not in jail.
No.
The impugned order says...
You have to deposit the money. That's what it says.
My lords, the impugned order strangles me into the level of conditions it has strangled me to.
Which case are you there?
My lords, item 14.
14 says petitioner shall execute a bond for 1 lakh to 2 solvents. That part, that is wrong. And further condition, petitioner deposit 40%. So you have to deposit that.
Your lordships, I'll just indicate. The sentence is only...
10 lakh rupees is the amount.
Send 10 lakh. My lords, difficult for me. But my only submission is...
You can afford to come to Supreme Court, but not pay,
lords,
not pay 6 lakh.
It's a pro bono matter. My indication is the analysis of how much he has to pay was done because he was already in jail is what the High Court thought. It's actually not true.
We have understood that. We have told you it's in 2 parts. We said that the second part.
Some time would your lordships
Time will be. Subject to the petitioner depositing 40% of the amount of compensation as determined by the trial court within a period of tell us what is
6 months and in 2 installments. I shall do so, lords.
Sorry?
6 months and in 2 installments.
6 months is take 3 months. 3 months.
I bow down, my lords. 2 installments would your lordships consider?
3 months would be 10 installments. How does it matter? The operation of the where's the trial court? Suspension will order. The sentence imposed on the petitioner with a trial court call.
Page 42 is the trial court's.
Page 29 there.
29
Shall remain suspended. Full stop. The petitioner is you were never arrested, no? Post conviction, the petitioner was never arrested. This is what is stated in part. Unlike what the High Court thought it to be otherwise. Needless to add, the petition shall furnish bail bonds.
My lord, serial number 15. Am I audible, my lords?
You are audible, very much audible. What is the stage of the trial? Do you want to know?
No, charges are not yet framed, my lords. For 4 years and 2 months, I am behind the bars.
Generally, we would have not interfered.
No, I am in jail, my lords. I am in jail.
एक मिनट order तो सुन ले.
I am in jail, my lords.
Ordinarily, we would have not issued notice. But considering the fact that the FIR was registered against the petitioner, that FIR was registered on 23rd of June 2021. And in relation thereto, petitioner was arrested on 29th of June 2021. And as we are informed till date, charges have not been framed. We issue notice calling upon the state stroke prosecution to explain as to why thus far the calling on to appraise as to whether A, the investigation is complete, B, the charge sheet stands filed, C, whether the trial has begun, D, whether the trial is delayed on account of the petition. Notice returnable date.
My lords, returnable date, my lords.
Yes, sir.
Returnable date, my lords.
Sir, 1 minute, where are you speaking from?
I am speaking from Pune, my lords.
Mr.
Mahendra Kautsale.
Mr.
Mahendra Kautsale.
Mr. Konchale, the Supreme Court, the attire is totally different. The
No,
dress may be dispensed there in your court.
I seek
But not
apology
in
for
this
that,
court.
my lords. I seek apology, my lords.
We'll give you a date.
Obliged, my lords. Highly obliged.
May I please? There are 5 kgs of heroin was found, my lord. The respondent, my lord, is
Short notice, ma'am. Agla, service to be effected through SSP. 4 kg of heroin,
5.
5 kg of heroin, 4.
And he's a habitual offender, my lord.
No, that apart, the only thing you'll have to explain is Tufan Singh. We'll have to explain Tufan Singh.
That's explained in note.
Because the testimony of the statement was in co-accused, that's it.
Yes.
We are issuing notice, but be ready to answer
Yes.
that.
Obliged.
Sir, 1 minute, 1 minute. You have to find an answer for the.
My lord, Mohit Agarwal is also there.
They are only saying his sister.
Yes. But he's also an habitual offender. That's a finding by the trial court.
Whatever it may be,
We'll look into that.
but your grounds, you were silent.
Lord, we have told, my lord, in the trial court there's a
In your
finding.
grounds before the SLP, we were looking for the answer, it is not there.
No, we have said, my lord, at least the synopsis I found, my lord. I didn't go to the grounds, but synopsis we said that it is an habitual offender. And he was convicted earlier also.
Just where do you say that?
My lord, in the synopsis, my lord,
Ma'am, who drafts Union of India bills these days now?
There is a panel.
On panel, you must also.
my lord, at page C, my lord, P10,
Page 11, it is a question of
HC,
my lord, page C, my lord, the earlier page, your lordship may say, the impugn order has failed to consider the involvement of respondent 1.
नहीं कहाँ पे पढ़ रहे हैं आप?
My lord, I am reading it, synopsis,
हाँ,
page B end and page C starting. Page C starting is a history cheater and repeat offender has been previously convicted by the sessions.
भाई अपना. Can we borrow your paper?
Yes.
it is also a specific question of law at page 11.
Page 11 also, my lord, a question of law is.
So repeat offender.
Page 11 also a question of.
हिस्ट्री शीट तो कहाँ पढ़ रहे हैं आप?
Repeat offender.
Repeat offender. He was convicted and also in question number 4,
Page 11.
whether the honorable High Court.
No, in your ground synopsis where.
Lord, page C top, Lord. History sheeter on the top of that page.
What happened to this conviction on?
He suspended, his order was suspended by the Delhi High Court.
Here.
Again, he indulged in this.
Please. Learned ASG submits that in relation to the very same nature of crime,
Yes.
the petitioner
Respond.
was previously convicted.
Respondent.
This is the details.
And the appeal against conviction is yet pending consideration before the Delhi Court. Even though the sentence of suspended signed served. It is only during the pendency of the appeal that it is only thereafter.
Yes.
It is only thereafter that the petitioner has allegedly committed the very same crime, crime of the very same nature. We notice that the total
Quantity.
recovered the total contraband, the contraband recovered, allegedly recovered from the main accused
4935.
is of
4935.
huge quantity, that is 4935 grams of
heroin.
heroin. On the statement of the main accused, the incident petitioner stands, the incident respondent stands arrested. For the as per the investigation conducted, the complicity of the accused could not be ruled out. Notice to the day.
My
We
lordship,
notice that none of these aspects have been considered by the High Court.
no, it's the respondent, my lord. Your lordship said petitioner.
None of these aspects have been noted by the High Court. Notice.
Obliged.
Item 17.
There in item 17. Password. Password.
Item 18.
This is against a, please, Lords, this is against a rejection of regular bail mallots. Mallots, no recovery has been effected from the
Brown
petitioner.
sugar is there.
Mallots, but no recovery has been effected on the petitioner. Mallots, the trial is not proceeding. There is no witness that has been examined since 2023 December. Mallots, trial has
Frame.
charges from Mallots. Only 4 witnesses have been examined in the year.
4 out of 17 have been examined. Don't say no witnesses have been examined.
Mallots, after 2023 December.
That's all right. Then trial is in progress. You can't.
Mallots, I'll give you the status. Mallots,
Since 2022 and 2025, in 3 years, what more do you need?
Mallots, nothing more has proceeded after.
What more do you need? Sorry, 5th bail application.
Mallots, may kindly consider, Mallots, nothing has been effected, no recovery. Mallots, no criminal antecedent, Mallots.
No, in this court, you don't even have to open your mouth.
Mallots, may see there is no criminal antecedent. The petitioner has no criminal antecedent, Mallots.
We are not into that. What we are saying is that you are behind bars for 3 years. We appreciate that. 4 out of 17 witnesses have already been examined.
Mallots,
Therefore, this is not a case of.
that is the secondary ground, Mallots. On merits, Mallots, may see no recovery has been effected, Mallots, from the petitioner. There's no recovery, Mallots.
Not at least.
I may permit to withdraw that, Mallots, in that.
Information to withdraw. Simple withdrawal.
Also, the first bail application was dismissed by the Honorable High Court, my lord, on the grounds, my lord, that the petitioner could not join the investigation, my lord, when the direction was given.
You are a nun. Since when you have been impersonating so many people, sir? It's not a case of a bail.
Lordship,
12 antecedents.
my semester, my lord, I have placed on record 2 orders, my lord.
There are 12.
Or one of Honorable Patna High Court, my lord. Lordship,
इस कोर्ट में 1 मिनट नहीं लगता.
Lordship, only kindly see 2 orders, Lordship.
आपने देखा ना?
In one of the cases, Lordship,
have to speak.
that's right, my lord. So I was also hopeful, Lordship, my
Why
submission.
we are saying so? We are telling you. You have impersonated yourself as an IAS officer, number 1. 2, anyhow, that alone doesn't weigh. 12 antecedents of the very same nature. Sorry,
Lordship, that's a, my lord.
it's not a case of a bail.
Only one submission. In one case, my lord, kindly see the bail order of the Honorable Patna High Court, Lordship. My lord, kindly see. That is at page, my lord, page 154, my lord. What has been said in the order, Lord? Kindly see. 154. Same type of allegation was there, my lord. That, my lord, Lordship, may kindly have page 154.
Sir, thank you.
Lordship, kindly have, my lord, please. In one of the cases, Lordship, kindly same type of allegation, Lordship. Same type of allegation, my lord. And in that case,
When you are committing the same crime now.
no, my lord. My lord, kindly. And second, my lord.
Yes.
Sorry.
Next.
Your Lordship, I am against the rejection of
Yeah,
issue notice.
Lords, I
You
accept.
don't want?
No, yes, Your Lordship.
Lords, I accept the notice, my lords. I will file counter, my lords.
Counter A bail granted.
Lords, I will check the antecedent, my lords.
You will check the antecedents. Yeah. Thus far, there is no antecedents on record.
Then I will seek a section, my lords.
Huh?
Then I will seek a section from the department.
So he accepts notice, A bail.
I'll
Kohli, how are you? Nalish?
Yes,
Always?
fine, sir.
Yes.
Shiva, I'm appealing for, this is the legal aid matter, my lords. Petitioner is in jail since 2010, my lords.
1 minute. 1 minute.
My lords.
Any appeal preferred by the state against the acquittal?
No, they are not equitable.
No, my
They are
lords.
inside-
May I please?
No.
ऐसा करिएगा.
Item 21.
Item 21, I'm appearing, my lords. This
Are
is
you
against the rejection of the bail, regular bail, my lord.
No,
While
ma'am.
pending-
1 minute. Is it a fact that he is behind bars for 24 years?
No.
20 years approximately,
20 years.
21 years approximately. He's 60 years old, my lords. And the case of the prosecution is under section 396, he has been convicted. Whereas the defense-
1 minute. Our query to you is that there were 8 accused, 4 were convicted, 4 were acquitted. Have you filed any appeal against the judgment of acquittal?
There are
No, my
only
lords.
4.
There is no acquittal.
Sorry, lords.
I may have wrongly read it, but let me read, because you have pointed out only 4 accused, I'll read it again.
Yes.
आइए, come to page 64. The accused Manilal Chhatrapal Kallu Hushirama found guilty of 396.
Yes, my
The
lords.
accused Chhatrapal Kallu Hushiram Omkar are acquitted of 412.
12. Only one section they were acquitted, and 396 they were
I stand
convicted, my lords.
I stand corrected.
This is
And the
the,
petitioner is A3, my lords here.
No, have you filed any appeal against their acquittal in 312?
No, my lords.
Why?
We are, I am appearing for A3, my lords, who is the petitioner herein, in item number 21.
Huh?
And we are seeking regular bail, my lords, and the early disposal of the.
I thought you were for the state. You said you were accepting for the...
no. She's appearing for petitioner, my lords.
Then whom are you?
I'm assisting, my lords. I'm assisting consultants.
I thought she had accepted notice. That's what she said. In terms of, in relation to an FIR dated 27th of July 2004, petitioner stands convicted
Yes.
by the trial court in terms of judgment dated 13th of October 2009. Petitioners kar lijiyega. All petitioners are here? All convicts are here? No?
No, my lord. I'm only one. my
A3,
lord.
A3, my lords.
A3.
Petitioner is A3.
One amongst the 4 convicts
Yes.
has preferred the instant appeal. Yes.
Bail.
Cut out. In relation to an offence in relation to an offence which was registered with a FIR dated 27th of July 2004, 4 persons stands convicted by the trial court for having committed an offence punishable under section 396. However, in relation to an offence under 312 IPC, all of them stands acquitted. So, appeal against the conviction is pending consideration before the High Court of Allahabad, High Court of Judicature at Allahabad, Lucknow bench. Appeal is by all 4.
Appeal is by all 4.
One amongst the 4 has preferred the instant appeal. One amongst the 4, namely Naam de dijiyega, has preferred the instant appeal, assailing the order dated 26th of July 2010 rejecting the prayer for grant of bail. Now, we ask you, ma'am, one thing to begin with, that have you filed any application for early hearing of the appeal? Because 24 years
No.
have passed by.
No, my lords, because the petitioner is quite helpless. He has no one to defend. So amicus was appointed in the year 2023.
1
And
minute. So,
the matter is nearing the disposal of the appeal. Lordship may kindly direct the early disposal of this criminal appeal, enlarging him on the bail, because what really is seen is he's been falsely implicated in this matter, because
1
the very
minute.
identification.
1 minute, Ms. Begum, 1 minute. See, you ought to have first the order imputed of the year 2010. You should have immediately filed an application for early hearing or a fresh application for release of bail.
Yes.
We have lost advisory jurisdiction. You should have done that rather than coming to this court. We noticed that.
My lords, other accused has filed their second and third bail applications, which were also rejected. Those we have filed in the middle.
The accused, that the petitioner, instant petitioner, is behind bars for more than 24 years. And the appeal is pending consideration for last 15 years. Ordinarily, we would have not issued notice, but however, in the attending facts and circumstances, we issue notice to the
State of view.
Notice to the registrar of the report of judicature at Allahabad, Pura भेजिएगा. Directing him to submit a report as to why the appeal referred in the year 2010 has yet not been listed for hearing, and what steps are being taken for disposal of the appeals pending consideration, where the accused are suffering incarnation for a long period of time. Let the state, we also should notice to the state service to be effected through the standing council, based on registrar judicial to transmit the order to the concerned court latest by tomorrow. During the course of the day to be released on 2 weeks. They will file their affidavit.
Obliged.
There are how many such the registrar shall indicate, shall furnish information in a tabular chart as to how many such appeals are pending consideration where the accused are suffering incarnation over a different period of time.
Very grateful, Lords.
Great.
Obliged.
Yeah, over a different time for more than 10 years. For more than 10 years. At least for more than 10 years. Incarnation for it. At least. This also means that is the first year. Do you have any idea that how many such cases, Begum?
No, my lords, I have no such idea.
But if you go on the site of the NJDG, you will find this
Yes,
data
my
is
lords.
available.
Oldest cases pending.
Oldest cases pending and also category where, because you see in Patna what I did was I picked up those cases where people were behind bars and immediately listed those appeals for hearing. And we realized that in 90% of the cases there were acquittal, be it for whatever reason. But no, people who are behind bars for long period, they must their appeals must be given priority and heard at the earliest.
Yes, my lords. On the last occasion, if your lordships permit, one matter, my lord, before it came up for hearing, petitioner died, my lord. He was 71 years old and he undergone incarceration for 10 years. It was so painful and shocking. And he was also falsely implicated.
No, we can't comment on that, but the only thing is that we must put our house in order. Thank
Very
you.
well, my lords. Obliged.
There is a delay, my lord. After that,
Yes.
item 22.
Delay is condoned. The suit for declaration title concurrently dismissed.
Yes, concurrent.
All throughout. There are
But only one thing is that actually this is between the family members and the land was going to outsider. And the ROR was in my name. That is the only point. That is otherwise the land was given to we are family members.
no, but now land transfer has been handed over.
But ROR was standing in my name. That both the
Hey, you see, you have no title. That's it. Can't do anything. Sorry, sir. Thank you.
My lord, kindly appreciate here, but Order 7, Rule 11 application was dismissed. The ground that it was moved at the time of the entire evidence is coming to end, my lords. PW5 up to PW4 it was examined, my lords, and PW5 also examined in the cross-examination.
No, 1 minute, gentlemen.
Please, my lords.
What is the date of the agreement?
Agreement, my lords, 1975, 5/12/1975, my lord.
Three questions you have to answer.
Please, my lords.
What is the date of the agreement?
5/12/1975, my lords.
When did the vendor die?
My lords, he died, that was not on record, my lords. That one did.
We'll tell you 2010.
Yes, my lords. He
And
died.
when did you file the plaint?
My lords, it's a file on, my lords, in 23, sir. 23/9/23, my lords.
And how do you explain from 75 till 23?
My lords, my explanation, my lords, trial court, my lords, it's an initial stage, they would have made application, my lords. I'm answering, my
You
lords.
are not answering, please.
I'm answering, my lords, sir.
Under
Yes,
711,
yes, my lords.
limitation is an issue,
Yes, my lords.
correct?
Yes, my lords.
Now, limitation may be a mixed question of fact. No problem.
I'm pleased, my
No,
lords.
no difficulty.
I'm pleased, my
No
lords.
difficulty at that.
I'm pleased, my lords.
But from 1975
Yes, my lords.
till 2021 or 2023, you
Yes.
have to travel.
Yes, my lords.
Now look at your legal notice.
Yes, my lords.
In your legal notice, you nowhere say
My lords, I admitted that in my complaint, my lords, in the legal notice
in your
also.
legal notice,
Yes, my lord.
you nowhere say the reason for delay that you were always ready and willing and that they have refused. Number one.
Yes, my lord.
In your cause of action in the plaint also,
Yes,
you
my
don't explain.
Para 11, my lords, is the trial court, it says. Kindly see the para 11
You
of
have
the
not seen
complaint.
the trial court, gentlemen.
No, no, my lords.
It's only a plaint.
Yes,
For
plaint.
11, only the plaint is to be
Plate,
seen.
plate para 11, my lords. Plate para 11.
Page 40, read.
Yes, my lords.
Read.
Yes, my lords. 57 page number, my lords. No, sorry, my lords. Sorry.
57 नहीं है,
No,
35
no,
to 40.
35 is the para number 11, my lords.
Read.
Yes, my lord. The cause of action for the suit arose on 5/12/1975, my lords. And the date of execution of the unregistered settlement agreement by Sri Nilkant in favor of the Govindappa, son of Puttappa. And thereof the defendant being the elders of the deceased Sri Nilkanta and being the joint cathedral of 2 acres 16 guntas, including the suit scheduled property, have failed to come and execute the registered sale deed in favor of the plaintiff as the legal heirs of this is Govindappa. In spite of the repeated demand, request and legal notice dated 23/2/2021 by the plaintiff, Pannikere village, Kasaba, Hubali, Durga Taluka, and subsequently within the jurisdiction of this honorable court, and the suit is today in the time, my lords. My lords, kindly appreciate, my lords. One second, my lords. My lords, one minute. I will.
Please call the next case.
My lords, the High Court can, without there being, my lords, even my lords, kindly consider, then the High Court would have said what my lords have said. Nothing it said. He said that another judgment I decided and. My lords,
1 minute.
My lords, the reversal of the IAM.
No, 1 minute now.
Please, my lords.
Serious note.
Please, my lords.
From 1975.
Yes, my lords.
Till 2021, when you issue legal notice.
Yes, my lords.
You have, A, do not say that you have been ready and willing. 2, you have issued and asked them to, you have presented yourself before the registrar for registration of the sale deed. C, you have never asked upon them, called upon to register the sale deed. 4, the vendor dies in the year 2020. Even the LRs you don't call upon. Thank you. Next case.
My lords, my father was there all the way. My lords, my father was recently.
Thank you.
My lordship, may I kindly appreciate. I am a 75 years old person. I want to reside at my father's ancestral property. The respondent is my real brother.
The LC has been appointed.
My
Page
lordship,
23.
yes, my lordship. The LC, the pleader commissioner was appointed. He has submitted his report. He has submitted his report without presence of any land surveyor. He has identified the plot number 1510.
We'll issue an LC from here only. We will bear the expense.
Yes, my lordship. I am ready to bear the expense.
From Supreme Court?
Yes, my lordship. The problem
cost you a bombshell.
My lordship, the problem is, my lordship, I have two contentions to raise. The Honorable High Court has said the preservation of the suit property is required.
What people?
Yes, my lordship. I have only one small submission. Only one small submission. My lordship, let me allow to repair and renovate the property, because end of the day, the preservation of the suit property.
Someone from Bihar here itself will cost one. Aapka kitna fees hai? Sorry to ask.
My lordship, I have only one small submission.
Matter is still pending.
Yes, my lordship, only one small submission.
It's an interim order.
My lordship, only one small submission. My lordship, only one small modification. That status quo is there.
It's an interim order, sir.
Yes, my lordship. Let me say only one thing. My lordship, only one. Let me allow to repair and renovate the property, because I am residing under open sky. The problem is that I am not able to even repair the property. I have filed the partition suit.
My lord is saying we'll issue notice. You will bear the expenses of the litigation for the other side.
Yes, my lordship, I have no issue, because I am residing under open sky right now. Just want repairing and renovation.
Deposit 1 lakh rupiah, 1 lakh here.
Yes, my lordship.
Registry of this court.
Yes, ma'am.
And we'll see whether it is to be given to as a litigation expense to the other side, or to be returned to you. We'll see.
Yes, my lordship. I am ready to. I have only one small prayer of modification, repairing and renovation of the property.
In the absence, we can't do that.
Yes, my lordship. I have no issue. I will deposit rupees 1 lakh.
Petitioner is ready and willing to deposit sum of rupees 1 lakh in the registry of this court within 1 week from today.
And 2 weeks, if
the said amount shall be now orders with regard to the orders as to how the said amount is to be utilized shall be passed after we hear the said notice. Thus the returnable dash. Who gets it?
Much obliged.
Wait, please.
We notice that the parties are neighbors, and the petitioner intends to carry out repairs of the wall Wall, na?
And the roof also.
Wall and the roof of the house at his own risk, cost, and consequences, subject to the outcome of the means.
Much of them. Much of them.
Item 25.
Wait, please. Manoj's complaint lodged after seven.
Sorry.
Manoj, please see the disproportionality. Manoj, I have been awarded this major penalty under Manoj's clause 11. May I just pass it on?
You can't say it's a friendly loan.
Manoj,
4.5
Manoj,
lakhs rupees taken as a friendly
Manoj,
loan.
given
So
back.
you wanted,
Manoj,
you
given.
wanted someone to be given employment in a civil court, class 4.
Manoj, amount given back. The complainant says, I don't want to pursue this complaint. Manoj, may I say this?
Sorry, Mr.
Manoj, may I just, Manoj, please just have a look at the penalty award. No, Manoj, I'm only on to the quantum.
Sorry.
Manoj, please have a quantum. Manoj, I can't be, Manoj, I am disqualified.
Nothing.
Manoj, I'm disqualified.
You are selling the judiciary.
No,
Sorry.
Manoj, I'm disqualified, Manoj,
Sorry.
from any further employment, Manoj.
That's good
Manoj,
enough.
to that extent only.
Cannot
I'm only
say
request.
please, sorry.
Manoj, to that extent.
Next case, please. Sorry. Next case.
May I please? The concurrent finding of fact, as per the declaration injection is considered in RSA. Second appeal. The trial court will held that, but the suit is barred order 9, rule 9, and also limitation law. Article 58 may be applied and barred by limitation for 12 years. But it is set aside without, they are not presented a substantial question of law. But it's set aside in a RSA without any give finding.
No, it has not been set aside.
Set aside.
The appeal has been set. No.
But two appeals.
No.
2 appeals. But please come to trial court.
Oh, 1 minute.
Set aside.
You're right.
Please. In RSA, without framing a substantial question of law, they are not presented at all. Page 7 saying that no such frame.
No, para 7, page 7, substantial questions are there.
But page 7, the High Court recorded that they are not presented. Page 7, but the first.
Yeah, you are not right in saying no substantial question. Para 7, substantial
question. This is my appeal, first question.
Whatever it may be.
My appeal. Their appeal, 7386.
Hey, Baba, please understand. Questions have been framed considering the materials in both these appeals.
But however, there is no finding.
No, you are not wrong.
Please come to the trial court.
You are not correct, sir.
The High Court say, considering the record, this court is of view that.
You only tell us one thing.
Please.
Who invoke order 9, rule A, whether you were there or not is something which we need to see.
The defendant was present.
He was present.
Present, my lord. Defendant was present.
Where is that document?
But it was recorded in the.
Where is that document?
Recorded in the trial court itself.
Please show.
Please. At page 148, my lord.
The CPC then, please. That you were present, where is that?
My lord, at page 148, para 33. My lord got it. It admitted and proved from exhibit D3 that the earlier suit of the plaintiff was dismissed default, but the plaintiff failed to invoke order.
Was that where you were present? In the earlier suit you were present is what we are asking.
My lord, please come to the dismiss for default order, my lord, at page. Please go. But page 65, my lord.
Page 60.
Page 64.
60.
64, my lord. 65. The R&D present phrase time. No proper adjustment reason of the concerned payer. Plaintiff has not shown any interest in the
Where is the defendant's presence is what we are asking. Sir. We say to invoke
order 9 rule 8. Order 9 rule.
Your presence is must. Where is that?
But I'll produce the entire order sheet.
Sorry.
We'll produce that. Entire order sheet will produce.
अपने हस्बैंड के ब्रदर के खिलाफ सूट फाइल की हस्बैंड मत किया था Suit dismissed on the 4th. Here the next integrates the तीसरे आदेश तो उसका कंसेंट डिक्री है फिर वाइफ ने उस कंसेंट डिक्री को भी चैलेंज किया और इसको भी कहा कंसेंट डिक्री को भी चैलेंज किया और काम में शेयर दीजिए जब शेयर तो ट्रायल कोर्ट ने क्या किया कि पार्टी अलाउ कर दिया बट उसका शेयर नहीं तो
One more issue. There is a limitation on the ground of limitation with the 12 years. The earliest suit in 1991 disposed of the 21-1 to the 1995.
Suit for partition, there is no limitation for partition.
It's not a partition.
Partition and challenging the decree, it's all right. The wife must get the share.
No,
Lady must get share. Simple.
Lady is not proved that she is the wife of the one the Reverend Siddhappa.
Thank you, thank you.
But the concurrent finding, one more issue.
Finding for all courts,
but one more issue, page 22. 22. The prayer.
Concurrent finding in favor of the wife by all the courts.
But the declaration and injunction was rejected by the first appellate court as well as Rajasthan court.
Finding with regard to her right, what you are challenging today.
But the right created from partition. 3 courts concurrently held that the partition deed is not proved. But one more issue, page 22. The relief granted, which was never claimed. Page 22. Page 22.
Next case.
Which relief was never claimed.
Next case, please.
Please, Lords, I must firmly submit, my lords, there's a delay of 710 days in FIR.
Dismissed. No, dismissed.
On the ground of delay.
On the ground of?
Delay.
Delay.
Great.
Just like we never dismiss on the ground of delay actually. Delay in the attending facts and circumstances dismissed, not to be treated as a binding.
Obliged.
I am appearing in item 28. There are three key submission.
No, there cannot be any impediment, sir, because the cause of action is totally different and distinct.
Well, kindly appreciate.
For a will to be probated is different.
Probate is not required.
Thank you.
1 minute, kindly see. Probate, this court had said.
We understood the issue or not, number one. That's the only issue.
No, Your Lordship had understood. Your Lordship had partly understood this. Yes, sir. The second part is the true judgment of this court says probate is not required. This court says in Rajasthan, if the probate is not required, number one, and the letter is not a.
1 minute. You are seeking impediment.
Correct, Miller.
On what ground?
That we are the direct descendants of the Maharani. Number one.
You are seeking on the basis of the will.
Yes, certainly on the will, Miller. certainly, but no, but the High Court decides that probate is required, my lord. My respectful submission, probate is not required. This court had said, my lord, in two judgments. In the two judgments,
We have said in the.
there are two judgments, my lord, which I referred.
Just 1 minute. There's something which may be of perhaps your. Can come to para 25. That's the only thing which.
Para 25 minutes.
Does this not foreclose is right?
Which is
Yes.
not probated one. Which is not probated one. Yes. They say in the case on an evident.
Just 1 minute.
I'm sure.
If he had produced a copy of the will.
No, please understand. Is hopelessly barred by limitation. Now, this observation here.
My instructions are, if my friend wants to file a substantive suit, your lordship may direct that this observation, let it not come in our way.
That will be decided on its own merit.
Let it be decided on merit in accordance with law, my lord, subject to limitation.
Regarding the earlier, my lord, what I was saying is, this court had said consistently, no probate.
What is the fine error? Please tell us in the judgment.
Yes, my lord. Page 18, paragraph 25, my lord.
वही तो हम कह रहे हैं.
And they say not probated one. Only ground on which I
set aside this para 25. That's it.
Yes, my lord. No probate is required because this court had said, and if no probate is required, my will is enough.
You approach independently.
No, the question is today the judgment of the High Court.
25 will not come in the way.
No, what I am saying, today the High Court judgment is right or wrong. Consistently this court had said, in Rajasthan you don't require probated. Yes, yes. And unfortunately only on this paragraph 25.
Para 25 will expunge. What more do you need?
We'll have to go into your lordship earlier said something else.
Otherwise, section 50.
No, we picked up the file to say that para 25 would be expunged. This is what we are saying.
I'm obliged. Thereafter, we certainly can go for improvement.
It does because the will has been executed in Bombay. But I don't know if he maintains a very well, let it be decided.
Yes, on merit, let it be decided. And the direct owner.
For the purposes of limitation, your lordship may clarify. Tomorrow it should not be that your lordship have set aside the of limitation.
Having a learned counsel, you're accepting notice.
Yes.
Yes, my lord.
You're for all of them.
1 to 3, my lord. 1 to 3.
Having a learned counsel, no. Then notices have to go to all of them, na?
Yes.
Yes, please.
But there are others are performance.
There are only.
Others are performance.
There are performance.
Only we are the.
I am the person who had filed the writ petition.
The contesting respondents, namely 1, 2, 3.
Yes.
Accept notice. The other respondents are just pro forma nature. They were pro forma even before the High Court.
Yes. Yes, we are the writ petitioners.
We don't know.
I do not know whether they are only performers.
They were performers.
Purchases of the property.
We do not know whether they were performers.
I doubt whether they were performers.
They were performers.
Because there is nothing written in the judgment that they are performer respondents. Otherwise, there will be another round here, minute. So it's better.
Can't be because your lordship may just see the writ petition.
I am not on the petitioner, please. I am only the point that the others are the performer or not.
Yes, in the writ petition, yes, they were. That's my instructions. That they were performer in the writ petition.
Then solve it. Rest are performer respondents.
Yes.
And were also so before, even before the High Court.
Right.
So, having heard learned counsel of the parties, we have the considered view that the observation made by the High Court in para 25 needs to be expunged, ordered accordingly. However, all contentions raised by the parties are left open to be adjudicated.
Lordship may clarify, including limitation.
No.
All contentions, however,
all contentions
left open to be adjudicated in an appropriate proceedings as and when the same are initiated by the parties. Stands disposed.
Very good.
Great. The deletion allowed.
I'm ready.
Yes, Lord.
Will issue notice. May issue notice. This. Service.
I beg to appear for the petitioner. The judgment which the Honorable High Court relies on is a post-conviction judgment. So during the time of an appeal, if you come and say that handwriting analysis was not done, the High Court is writing that judgment to say that it's not a good ground.
It's a question of trial, sir.
Today I have come before trial. Today
You will not protract the litigation. Please pay the money or put an end to it.
My lords, it's a question of trial. Let this application be decided.
No. Application of forensic can be done. See, do you dispute your signatures? No.
I did not.
Therefore, that's the end of the matter.
My lords, that view was taken in a post-conviction matter. My lords, if your lordships.
Thank you.
Rest of the contest is written by your clerk also.
I'll just.
Your signature is what matters in a check.
I'll just indicate one thing, my lords. If your lordships issue notice on this matter, the whole issue of blank checks, perhaps, my lords, your lordships will be able to address.
No.
I leave it at that. That was the only thing, because not post-trial. It's an application which comes pre-trial.
Thank you, sir. Thank you.
Leave it at that.
20,000 you must pay to your wife.
My lords, a couple of submissions, my lords. First of all, my lords, the wife at the time when she had filed the application has concealed the fact that she was working, my lords. My lords, I have placed on record certain documents.
You are not salary 60,000, no?
Now, my lords, at that time I was jobless.
Big chill.
No, my lords, from 20 till 23 I was jobless. I have mentioned, I have placed on record that also.
It will be subject to the adjustments. That's it.
My lords, just a small submission and then, my lords, she had filed the application in 2020. And from 2020 till 2023, he was jobless, my lords. He has in fact made submissions to that effect.
The possibility of settlement.
My lords, I'll be grateful if you lordships.
Notice limit confined only for exploring the possibility of settlement. However, the petitioner husband shall continue to pay the maintenance in terms of the interim property.
My lords, in the meanwhile, stay of the order because of warrant. Because warrant of arrest. Then, my lords, at least no coercive action because warrant of arrest has been issued on the matter is coming on the 11th. My lords.
If the petitioner were to clear the arrears and continue to pay the amount, clear the arrears within 2 weeks. And
my lords, may not say the arrears, my lords, because that is we'll sort it out in mediation, my lords, because it's a lump sum of 6 lakhs will be difficult for him, my lords. That's why I'm requesting, my lords. My lords may say no coercive action, and then settlement, my lords may just expedite and we'll try and settle it out here.
Then you deposit here.
Some amount if lordship send it, because he has just recently started working, my lords. He's in great difficulty, my lords. He's taking care of his mother as well and doesn't have a father. Of course, my lords, he'll clear the arrears, but for the time being, my lords, I'm just requesting.
To be deposited is the arrears be deposited in the court within a period of, before this court, within a period of 4 weeks, to be kept in auto renewed mode.
Can my lord say half, because it will be difficult for him to arrange 5-6 lakhs. He's 60,000 is earning, and that's the gross income, and he has to survive here and send.
Yeah, they shouldn't notice there only for exploring the possibility of settlement.
And my lords have said that no coercive action.
Should the petitioner comply with the order, no coercive action shall be taken. He'll just come back in 5 minutes.
Great.
So the letter has been circulated, my lord.
Letter for
adjournment, my lord. The advocate on record is not well.
some letter, some date. Adjournment.
Obliged.
My lord, in item 33, by the last order, my lord had directed the mother and child to be present in court. So my lord will interact. My lord, they are here.
She is resisting registration rights. Huh?
Yes, sir.
On the ground. Okay. So, क्या नाम है आपका? What's your name?
My name is Aditya Panda.
What's your name, ma'am? Come. Stand up. What's your name? Sanyam. Miss Sanyam, you are working with whom? Which is the item?
Item 44.
It will not come just now. ऐसा करिएगा. Do one thing. We want you to do one thing. Just take the child and there is a Mitti cafe here. Just offer her some chocolates or some tea or something. Or she won't have tea, but something to eat. Huh? Can you do that? She'll take her and just give her a chocolate or buy her a chocolate or something.
Thank you.
आप हिंदी समझते हैं? Does she understand?
No.
You don't understand. Can you just come in the front? We can't see you actually. Don't worry.
Bengal.
नहीं अभी तो सिर्फ इतना ही किया है.
She can understand Hindi, no? Or ki Bengali?
Limited understanding, my lord.
Bengali?
She speaks Bengali.
Bengali?
बेंगोली में बात समझती है, हिंदी नहीं.
তুমি একটু বাইরে গিয়ে মিষ্টি খেয়ে আসবে, ঠিক আছে? চকলেট, হ্যাঁ? না খাবে না, এখানে কিচ্ছু হবে না. আমার
বলো খাবো. ভয় পাচ্ছে খুব.
হ্যাঁ
ভয় পাচ্ছে.
ভয় পাচ্ছে এদিকে টাইটেন
नहीं कोई बात नहीं. आपका मामा भी साथ में जाएगा.
হ্যাঁ মায়ের সঙ্গে চলে যাও, ঠিক আছে? না কি
Thank you.
अपना बड़ा अच्छा फ्रॉक डाला है. You're wearing a very nice frock. Very good color, very pink, beautiful color.
माয়ের সঙ্গে ঘুরে এসো একবার কোর্টে ঘুরে এসো ঠিক আছে
फोटो भी लेना. फोटो भी लेना.
কি কি বল কি
क्या बोलছেন স্যার বলুন বুঝতে পারছি না क्या बता रही है आप
ঘুরে এসো একবার করে ঘুরে এসো
বলো যে আমি
কি
আমার সাথে যাবো
হ্যাঁ যাবো ঘুরে এসো
রাজি আছি যাবো
খুব ভালো
Some any other young lady lawyer? Let youngsters take this shot.
just take her around just to make
Okay, you also accompany. Both of you go.
just to go around
Just show around, take photographs, the child.
she will enjoy this
Let's go. ठीक है आप जाइएगा and then bring her back. My lord would interact with her in the chambers.
Yes,
in the chamber
Yes, ma'am.
during the lunch break
yes, madam. We'll be there.
ठीक है जाइए. Go, please enjoy yourself. Huh? Take photographs. Huh? And eat also something, some chocolate. Huh? Or some beer. Whatever you like there, you take. Okay? Go. Just take.
she must be getting intimidated by this lawyers but rational thinking this
So what we'll do is my lord would interact with her. Then today the mother and the child would be in Delhi only.
Yes, ma'am.
We'll take it up tomorrow.
Yes, please.
Tomorrow.
No, my lords, request my lords for for submitting on bail, my lords. Because my lords last hearing.
I just filed my Wakala 2 days back, my lords. Kindly seeking a 2 weeks time, my lords.
My lords has specifically stated, my lords, in the previous hearing that the state will file the counter before today, my lords. You are
2 days back, I had filed my Wakala, my lords. I received my instruction in 2 days. Can you seek a 2 weeks time, my lords?
Then, my lord, may I seek for bail, my lord. My lord, he has undergone, my lord, almost 7 months in jail, my lord. With 3 years is a 3 years is a sentence, my lord.
2 years.
3 years is a sentence, my lord. Well, already 7 months has undergone.
Conviction.
Yes, my lord. Concurrent conviction, my lord, for 3 years, my lord.
1 minute.
Yes,
Current, huh? Leave granted. Suspend. Bail.
I'm obliged, my lord.
Please, my lords.
I'm seeking 3 weeks time to file my reply.
My lords, my application for suspension of sentence is pending, my lords. 1.5 years I've spent already.
How much you have spent?
1.5 years, my lords. 1 year, 6 months.
And what is
My lords, may recollect.
How she died?
Life conviction, my lords.
My lords, may recollect. Time was granted to the state to file counter before the.
No, we recollect that concurrent conviction is what we are seeing also. How she died.
My lords, may call for the trial court reports.
Is there testimonies on record?
No, not all, my lords. My lords, trial court record may be summoned in that case. Leave.
The interim relief as prayed for, leave granted, hearing expedited. What we called for, we copy this. Obliged.
I executed for the petition minutes. As per the office report minutes, the service to respond number 1 is still awaiting.
Complete.
Minutes.
Service is complete.
Does the office report say something else? Minutes?
No. Was issued to the through the concerned SHO.
Yes, minutes.
Service is complete on number 2.
Yes.
And number 1 service
Still incomplete.
Incomplete.
Yes.
Let fresh notices be issued to respond number 1.
Let's,
by furnishing.
May I just request if Milord's permit? Since the report is awaited, if Milords may have it after 4 weeks in the meantime.
No, one says that no addressee no longer lives.
Yes, Milords. And thereafter, Milords, the report is that the service from the SH is still awaited. If Milords may just. Because Milords, since the new address is not available with us, Milords, perhaps we'll not be able to furnish the fresh particulars.
On his request, adjourned by 4 weeks.
Okay.
My lords, as per the item, as per the last office report, the report by the Registrar General of High Court of Chhattisgarh has been put on record.
I mean CPC. Yes.
And therefore we have not given
CRPC.
Copy of that. We have not been produced the copy of that. May I?
CRPC.
And as per the last order of this honorable court, and as per the last honorable court, judgment order of this honorable court, we were supposed to move forward with this submit.
Now we have seen a report of the registrar. He says that the copy was sent, but the trial court failed to take action. So page 388 देखिए. सब ये नहीं. Section 388. Now it's about time now. Can we see when the executive fails to perform, we impose costs. Now if the judiciary has failed to perform, abide by the law, can we impose costs?
On we have been coming.
See, read 388. Order of the High Court in appeal to be certified to lower court. Whenever a case is decided in appeal by the High Court under this chapter, it shall certify its judgment or order to the court by which the finding, sentence, or order appealed against was recorded or passed, and if such court is that of the judicial magistrate other than the CGM, the High Court's judgment or order shall be sent through the CGM, and if the court is of the executive magistrate, the judgment should be so. The court to which the High Court certified judgment or order shall thereupon make such orders as are conformable to the conformable to the judgment or order of the High Court, and if necessary, the record shall be appended in accordance with the. Now, here the facts are very clear that the appeal stood when the appeal was preferred. Page 40. Page 40. जब हाईकोर्ट में अपील किया तो उन्होंने कहा कि आप लोअर कोर्ट में अपना प्रेजेंस लगाते रहिए. Now, from this page 40 order, which is dated, date क्या है इसका? 2002. So from 17/2002, अब आप देखिएगा he was dismissed on 26th of June 2014. High Court का अंतिम judgment. Page 12 पे देखा। हाई कोर्ट ने जब अपनी फाइल 2000 पास किया ऑर्डर का डिस्मिस हुआ तो 26/6/2014 को। ठीक है ना, 26 हम it's about time now. The judiciary must also be held accountable, na?
Yes, my lord. But it's up to the court. That
No, don't leave it at that. You also examine.
they are.
The registrar's report very clearly says that the 388 was complied with by the High Court.
We have been, as per the order of the High Court, also we have been appearing.
We are not finding fault with you. We are to your benefit only. You are saying. Now, if the concerned magistrate or concerned court has failed to take cognizance of the report of the High Court under 388, then what consequences would follow? Just study on that.
Okay.
Because the High Court says very clearly that the trial court report was sent to the trial court with the report.
Mm-hmm.
And some Babu or some magistrate intentionally, unintentionally, has sat over the matter, and for 10 years you have been, 10 years you have been penalized, agonized, not penalized but agonized. You would have suffered costs, you would have suffered expense, you have suffered
great hardship.
Mr. Dave is discussing this. बड़ा सिंपल सा है 2014 में इन्होंने एक हाईकोर्ट ने ऑर्डर पास किया, उनकी कन्विक्शन हो गई, 2014 में अपील फाइल हो गया. No, we are the serious issue which we want to is whether we should or can and should the other way impose costs and upon whom. We are at about time the judiciary must not.
My lords, I don't, if I may, the thing here in, even if we put some cost on the district courts also, then it won't, because by this time we do not know that if
That's
the
a
same,
separate issue.
same,
They are separate issue. Your merits and what is falling from his lordships are separate issue. You are on the merits, that other part is on the larger this thing. I'll explain to my learned friend.
We'll have it next week.
Lordship, please.
Just to assist, recently there was a judgment called Sonu Abhinayotri on the similar kind of issue, 388. Very recently, on 2024, November.
Thank you. Let's take note of
yes,
that.
yes, ma'am. Yes, ma'am. Yes,
So
ma'am.
now the report of the High Court says that yes, we have complied with 388. The fault is now with the concerned trial court. So if that is what the High Court has said, then is it not about time that we start accounting ourselves?
Yes, ma'am.
What to do, what not to do is something. From 2002 till 2024.
2024.
2002 till 2024.
22 years.
The High Court says, when they file the appeal against conviction, the High Court says that you shall continue to appear, mark your presence before the trial court from time to time. And for from 2002 till 2024, till they get to know about the judgment, which was passed in the year 2014, they appeared. So from 14 till...
He's been going and marking his presence.
Marking his presence.
Yeah. After an acquittal, I'm assuming this thing.
No.
After conviction.
But whichever, any which way, acquittal or conviction would not really matter. So there's a total non-compliance of 388.
I'll be here next week.
Yes.
Look, we must hold ourselves accountable. So good. Anyhow, broadly thinking.
Yes.
We have perused the report of report submitted by the Registrar General of the High Court of Chhattisgarh. The relevant portion thereof is extracted as under the report पर dash to. Full stop. We request Shri Dave, senior advocate who is doing the court to assist us. And list the usual order of them. Digital copies based on that. We are into the larger issue.
Yes,
About time we hold how do we hold ourselves accountable?
Yes.
Sir Ashwani, perhaps you can also, we request Saab ka bhi naam.
But may I say something?
Yes.
Regarding Lordships, my humble submission would be that the High Court in its supervisory jurisdiction should inquire into the matter and fix responsibility of the person responsible for causing the mess. And then your Lordships may pass any order against the person responsible, because otherwise your Lordships...
what we are into something else. Of course, disciplinary action is something else. Now, we are into a larger issue. Is it not about time that we start? Some cost should be. How do we recompense them is what we are asking. If at all. It's a big issue. We know we are treading a very dangerous path My lord has already cautioned me. But then it's about time.
My lord, there's compensation, your lordship may always award, but that my submission would be against the state. If they have suffered
No,
some.
why state? Why state?
Because all the expenses of the High Court also is met by the state.
These are larger issues which are
My lord.
ultimately by the judiciary or by the state is something, but act is that of the.
Because of the some I'll say not inaction or action of the individual manning that place. Something has happened.
So
that is worrying.
Administrative action on the administrative side against him is one thing.
My
We are into a larger issue, sir.
who is to be against whom a compensation has to be awarded. That is the
correct.
But the maxim that act of court doesn't harm anyone, here it has harmed someone.
Yes.
Otherwise it doesn't.
Lord साहब का भी नाम साहब का पहले आएगा साहब का पहले Mr.
No, absolutely.
Sir,
I'll do it.
Honestly, we are
examine this issue, my lord. I'll examine this issue.
I think it's about time we must. Today in the morning, sir, for 24 years, the man is behind bars. 24 years. And his appeal is not being listed.
That is.
We should notice. You know in Patna how we dealt with those who are behind bars, immediately take them up, and you did a great this thing.
Not got listed all the death sentences.
Absolutely. Not only death sentence, and then all those 10 years of appeal. We were into it. Anyhow,
in spite of the fact, not that court is flooded with another issue, prohibition and excise matter.
That we have brought it to the notice of the authorities.
My lord.
That other issue, perhaps they may take some. Perhaps they.
That is also after few.
I know. Next, please.
Item 28.
Please. Settlement is there?
My lords, by grace of your lordship, my lord, mediation successfully completed, my lord.
I'm here, another paper book. 38 का. Settlement किधर है? Separate settlement.
Settlement agreement, Supreme Court Mediation Center. Background and referral to mediation, para number 1 to all cases, my lord. Para number 2 to 2.2 is the conditions, my lord. And point number 2.4 is the property and residential settlement of children, for children respondent. Plot number 22B, Girnar Cooperative Society, Paldi, Ahmedabad, approximately 300 square yards, shall be treated as permanent irrevocable gift to the minor children, Ansh and Hidans.
No, 1 minute. What about the marriage?
Lordship, they agreed to reside together. They agreed to reside together, to get married.
Where is that?
Your Lordship, para 1. Your Lordship, para 2.1.
Mutual consent to marriage post-divorce finalization. Both parties declare their intention to solemnize marriage with each other legally and in accordance with applicable law.
First marriage, he already got the divorce. From the first marriage, he already got the divorce. Now they intend to marry both. They were in the live-in relationship. And the divorce was going on. Now
Both
the
met
divorce.
with a Facebook ID, my lord.
To me at least.
In the live-in relation agreement executed on 18/11/2014, my lord.
No, correct. But what about the status of the parties? See, we are not talking to whether you were in law entitled to marry today. Are you in law entitled to marry today is what we are asking. What is your status today?
The earlier marriage was already annulled, my lord.
Where is that is what we have said. Earlier marriage between whom and whom?
Your lordship, 1.6.
Sir, 1.6 we've seen.
But,
Who's
Imansu was
Niyati
Niyati Ben.
Who's Niyati Ben?
Niyati Ben is the first wife.
Niyati Ben.
Is the first wife.
First wife. Himanshi.
Has attained finality.
Versus Niyati Ben finally decided.
Finally
By
decided.
judgment and degree dated 5th July 2025.
Okay,
Passed by another family court, my lord.
Today's date.
Much obliged. Highly obliged.
Your Lordship, in item number 39, the standing counsel is not available today because he's down with fever. Additionally, there is this one aspect that we tried to discover, which is other prohibition acts which have similar provisions. So there are 4 other states which have similar provisions as the
We are not into that. We are only into. So what we have done is that this list of the other matters, as we thought first, it was in my mind that we'll pass an order and then place it before the appropriate authority. Now that it has been independently brought to the notice of the appropriate authority, they are perhaps taking action of having it listed. So today he is in difficulty in this, we'll have it some.
No, he had taken my consent note.
That on the administrative side now, it has been brought to the notice.
Your Lordship may have it on a non-miscellaneous day for
Tuesday. So अगले से अगला Tuesday.
Much obliged.
On इनकी request. I think soon those matters will be listed together. Before it has to go for a 3-judge bench, it will be listed.
May I please, my lords? Because on the last date, notice was issued in the petition, my lords. I have a few submissions.
Yes.
My lords, there are numerous documents, my lords, that prove that I am the legal husband of Lakshmi, my lords. The first one is a notarized marriage agreement, my lords, on page number 62 of the petition.
Yes. No, but you see, there is a forgery. Any possibility of settlement?
Lord, as per our instructions, no.
No.
My lords, one submission. My lords, one submission, my lord. If a look be had at the charge sheet that has been filed, the charge sheet on page number 103, my lords.
Yes.
All the petitions with item number 40 have been charged with bigamy, my lords. The father, the mother, the brother, the maternal uncle.
Never discharge.
My lords, what I am.
Never discharge.
My lords, what I am suggesting is, my lords, it's a mechanical. It's only a formality that the charge sheet has been.
Forgery. That's the allegation. Anyhow, seek
My lords,
discharge.
the family members might be given some relief.
It shall be open for the petitioners to move to seek discharge at the appropriate stage.
Thank you, my lords.
Grateful. Grateful.
Yeah, please, counter saying that the petitioner has been released.
Has been released now. It has been released.
28th August 2024 after 22 years.
That's all right. In view of the counter filed by the state, indicating that the petitioner now stands released. The present petition has prayed for is disposed of for same to have become instruction. Grateful.
May I please, my lords? The service is complete.
Service is
As per the office report.
Sir.
Yes, because I am appearing on the state.
Sorry?
I am appearing on the state.
Then. Yes.
I don't know whether they want to file any counter or I can start.
I'll seek instructions, ma'am.
No, what about 2?
2 is served, but no one has entered appearance.
As per office report, response number 2 is already served. No appearance. Who's he?
Complainant.
Not a part. Response number 2 stands served. No appearance on his behalf. इसको हमें किस लगा? क्या बताइए किस लिए? बताओ। तो ये होते हैं पूरी न्यूज़। बोलो। मैं भी नहीं जानता सर। तो अच्छा है, I mean, I know more करूँ। बोलिए बोलिए। Yes, who's the junior most counsel in the court? You're the junior most come forward. Don't feel shy.
Yes, of course. Because he will feel shy, my lord. I feel shy at this age, my lord. He certainly will feel shy.
What's your good name?
Sanjay Nair, my lord.
Who's present in the court is appointed as amicus. फिर होता है, even if the respondent is represented through regular counsel, continuing to appear, usual order. Then a response within the state within 2 weeks, rejoinder 1 week.
But can I pray of stay of further proceedings? Now everyone is appearing, my lords, because otherwise.
My lord.
I had to stay in the High Court, my lords, for some time, and thereafter.
We'll see on the next day. What do you say? Is it going on?
It's going.
My lords, that's exactly what we wish to verify. As per the case status, it
But
seems
did-
like the trial has not been proceeding,
but
but we
did-
need to take that.
No problem. Put date दीजिए, छोटा date दीजिए, 3 हफ्ते के बाद.
Grateful, my lord.
Most of it.
If I may, lords, I appear for the petition in this matter. The respondent number 2 has filed a reply on Saturday. I seek time to file.
The possibility of settlement.
Think they should. I think they should. This is what I put to my client. They should go to the Kerala
mediation.
mediation. The Kerala High Court Mediation Center.
Kerala or Supreme Court?
They are both in Kerala.
Supreme Court, na? Very well. Supreme Court.
Very well.
Please, Lordship, I issued notice for the state government to file reply to the SLP as well as interlocutory applications.
What we'll do is we'll admit early hearing, leave granted, early hearing list in the month of November.
Milords, may I just pray for one thing in this? Milords, the trial court records may be called for.
Let courts of trial court.
Lord, he has already undergone more than 7 years. So if that
Therefore, November we said.
yeah, that very well.
Perhaps it may be allowed also.
Very well. I'm highly obliged.
Milords, trial court, Milords.
Trial court record.
Milords, it will
This
be
is after
it can be in vernacular. Milords may say, Milords, the difficulty, Milords. I'm just saying that.
Trial court records with the translated version of the testimony.
But this is after notice, Milord.
1 minute, 45 हमने दे दिया. 45 we will admit, be granted. Next.
But it may be expedited.
अभी state dismissal वाला case है.
But in the meantime, counter if any. Counter. I am appearing for respondent.
Already filed.
ये हमारे साथी रहे हैं, हमने इनको oblige किया admit करके. आप
I want to wear the counter.
30 सानियों तो काउंटर फाइल करिएगा लीव वाले केस में. लीव के केस में क्या काउंटर होगा, रिकॉर्ड आएगा. काउंटर, चलिए काउंटर.
Please, your lords. Lords, I appear for the petitioner. As per the office report, your lords, the sole respondent had entered their appearance. But there's one more, no counter on record. There's one more thing, lords. So at the outset, lords had directed to. Sorry.
Milord, I'm appearing for Milord.
Yes,
The
sir.
respondent.
Any settlement. We'll refer to mediation. He's ready
Yes,
to
Milord.
settle matter.
Yes, Milord.
Or you say both of
Please.
you have coffee and sort it out.
No, your lordship may refer it to mediation.
No, why mediation?
But the parties are in Bangalore, Milord.
Both are sisters.
Parties are in Bangalore, Milord.
Both are brother-in-laws. It's in the family. They can settle it.
We are the considered view that the parties to the list must sit and have the dispute amicably resolved. More so, considering their proximity of the relationship.
No, it's in the Supreme Court. Before the Supreme Court Mediation Center.
We said both of you sit.
Very well, very well, very well.
Let the councils
Very well. Very well.
sort out we request the learned council for the parties to pursue such an endeavor.
About until that. Lords, until then status quo may be maintained.
Status quo as
No.
on date shall.
Milord, he has not deposited the amount. As per
He's
the
got
order.
the checks here.
I've got the checks. I've got the checks. I'll deposit. I'll deposit it, my lords.
He'll be happy showing it digitally transmitted.
Because I'll deposit 10 lakh rupees, my lords. I've got the checks.
No.
I'll deposit it. Very well. I'll deposit. Supreme Court. Very well. Obliged, my lord.
These 7 Malords had directed to consider whether.
You were to get in.
Yes, Malord, it has been considered at the highest level. The problem is that being granting some benefit contrary to the rules will be. Yes, Malord.
Had it been as per rules, you would have given it or we would have given it.
Malord, there are 2 angles, Malord.
Just a minute, we told you pension to widows. That also you can't, in excess of your power, do it.
There are 2 factors, my lord. One, regarding only these 3 petitioners, implication is 65 lakhs, and Pandora's box across the country, my lord. All non-regular.
Across the country we can sort out, but is it 65 lakhs?
65 lakhs for these 3 people. And then there are connected matters also with this, my lord. So there was
your lordships in the connected matter, your lordships, the state has come in appeal, your lordships. The High Court has granted them, your lordships. And this is a consistent view of the High Court in all cases. The High Court has granted this and this has been implemented. It is not, in this case also, your lordships.
The High Court, see, against that they have come here now.
Your lordships?
Against the High Court, again, they have come here.
Your lordships, in the earlier judgment of the High Court, they have not come here, your lordships. And I have 4 points to make, your lordships. As per in one of the cases, your lordships, the High Court has considered 1972 rules, pension rules. Your lordships, then the matter may be expedited. I don't know, lordships, how my learned friend is saying that the amount will be 65 lakh thousand. They were, the lordships, I have not calculated
instructions from the department.
But I don't know that how this amount comes.
According to you, what is the amount then?
The
Because you are the claimant, you have to tell us. See, we were in agreement that you must get something, but
in similar cases, this High Court, this Honorable Court, there is judgments of this court in similar circumstances to direct to make payment of the pension, your lordships. I will place it on the next date, your lordships.
इसको recall कर लीजिए को recall कर लीजिएगा इनकी request पे adjourn कर please come with the judgment.
Your lordships, I have placed.
We want to help you.
Your lordships.
Yes.
He may file the orders or give me a copy so that I can also.
Your lordships, I will give a brief note of lordships, all my arguments to my learned friend, and I will also file before this Honorable Court, your lordships.
We are only wanting to know your orders which have been passed in similar cases with respect to very same subject matter.
Your lordships. Your lordships.
तो आज दीजिएगा ना.
Your lordships. I have brought it just now, your lordships.
दीजिएगा इनको दीजिएगा. So Chahat,
yes.
Look into it.
Yeah, I'll look into it.
The council seeks reliance upon certain decisions of this court, copies whereof stands supplied to who's assisting you? Naam dijiye.
Seema.
In this case, your lordships, also the High Court has only directed to give similar relief. The CAT has directed to give similar relief.
To have the matter examined and explore the possibility of dispersing the amount to the petitioners who are the widows in terms of the said order, if so applicable.
Your lordships, apart from that, your lordships, there is an poem which says that it has to be given of 1980. No. The CAT judgment deals with the Supreme Court judgment also.
Sir, you have to give the Supreme Court judgment, please.
Oh, okay. Your lordships, that is mentioned there. I will give him.
Give it, sir. We'll have it after 2 weeks.
Your lordships.
Mr. Chad, just see.
Yes, I will.
Put your best.
I did try, but the way they portrayed it, financial implication, and it was. I'll try again. If there is a judgment, it will strengthen my case.
Put your best. Next.
Could it be posted on non-miscellaneous day?
Your lordships, I appear for respondent number 2.
No.
There's one more reason because.
Respondent number 1, Your Lordship.
I'm for the respondent number 2 now.
This has to be heard.
Yes.
Excuse me.
When do you want it?
So just after 4 weeks, any non-ministerial.
Any non-miscellaneous day, my lord.
Tuesday को लगा दीजिए.
compliance of your
ये 49 में है किसी important matter. But Tuesday को लगा.
we have filed the affidavit with the Lordship.
In which case?
49. Considered every aspect, but unfortunately, regrettably, it cannot be done. Because the number is 1,400. They were not even in the employment, so we'll have to first convert them to government employees and then absorb them into the PWD. And above all, my lords, the pay scales have already been given to them. They've been given parity already.
That's not correct, my lords.
No, we'll have to hear it.
Yes.
We'll have it on Tuesday.
There are 4 judgments of this
important matter. Some Tuesday.
My lord, giving a fixed date.
Some date. Some date is being given.
50. Sorry.
I think 50 Your Lordship have been pleased to issue notice. Last order, my lord, required one of the appellant was NHB. They were those out not appearing. Therefore, Lordship directed Dusty. We have served them Dusty, and my lord, now who's appearing is NABARD, who were not the appellants before the High Court.
Doesn't matter. They've been so long, they have stepped into their shoes. That's good enough.
I have no problem.
Who's there?
For NABARD, my lord, then. Yes.
You're there. I'll reply, sir.
They filed their reply. I can, my lord.
No,
proceed.
no. Today there's no time.
Oh, I'm sorry.
No, why?
Well, Your Lordship never.
Would you like to file rejoinder?
I'll do that.
Rejoinder within, ma'am, isko bhi na Tuesday wale din mein daiye. Important matter.
Lordship.
Tuesday.
Yes.
Rejoinder within 2 weeks.
Very good.
As I beg to pay for the petitioner's state, as the service is complete, I believe no one has entered appearance of the respondent in the matter.
Not entered appearance?
Nobody has entered appearance. Service is
office report, service is complete. None has entered appearance. Then ma'am isko allow kar diyega. Ye.
May I point out that in the common order passed by the single judge, a batch of other SLPs
No, you give that.
which was remanded back. I'll just point out.
हमारा एक order है वही कर दीजिए.
On remand, it has been disposed of in favor of the private respondents.
We don't know. We'll only remand.
Very well, it will follow. Very well.
Oh, then we'll dismiss this SLP.
My lord, state is coming in SLP against those orders.
Why even mention?
So follow this. Thank you.
Next.
Grateful.
My lords, in item 52, there is a letter, my lord, circulated by respondents. Obliged.
Please, no. Because it's very
Service
uncommon.
is not complete.
It's very uncommon that the insurance.
So office report, respondent number 1 stands unserved. 3 steps of service. Number 2 and 3, Vakal, you're there?
Number 2 and 3.
Response 2 weeks to agenda 1 week. Next.
With a order dated 1st of August, I was appointed as an amicus to assist this group. Despite service, none has appeared for respondent 2, the insurance company.
Who's for the claimant? Only thing is, who's for the claimant? We must get the.
They were present in the last payment.
Huh?
They were present in the last.
National Insurance Company normally appears, let fresh notices because you see the amount is going to be substantial because it's going to be in dollars, the foreign currency. Let fresh notices be issued to the respondents, returnable dash, दस्ती कर दीजिए. Put date दीजिए.
On this occasion, your lordship said granted us one final opportunity to file a counter. I'm just
Mediation has failed now.
yes,
Yes,
I'm just
so
requesting.
last time they sought time saying that they'll want to file counter. my lord.
Lordships may just grant me one more indulgence, my lords, to file my counter. Just one more will place.
Otherwise, the pleadings are here, my lord.
Lordships may grant me 1 week, my lords.
1 week, he's saying.
I leave it to my lord.
Why don't you settle?
We've tried, my lord. We have umpteen times tried, my lord. But it's not working out, my lord.
That's the
Without
husband, my lords, is insistent that he doesn't want to live along with her. The wife is insistent that she wants to live. That's really
Let the parties remain present in court on dash. Let the parties remain.
very
Rejoinder 1 week.
Would my lords consider to keep it then after 2 weeks, my lord, so that they can arrange
some date maybe I'll make.
specific date, my lord.
Some date will be there. No?
Very
yes, my lord. Grateful, my lord.
Judgment letter.
Your lordship, I request for a reference to mediation. The party we have agreed.
Mediation. Mediation.
My lord, I have filed a counter. It is not on record.
My lords, I would like to file a rejoinder 4 weeks.
The judgment has to be set aside. So it's a weird judgment.
My lord, I will.
We'll remand it. We can say that.
My lord, please let. My lord, let the rejoinder be on record because I was.
Let the
My lord, I will put my submission. My lord, why it can't be remanded back, and why it is the right judgment. My lord, I will put for my submission otherwise. Because I thought that because like the counter is not on record, so my lord. That's why I am.
आजी कर दीजिएगा सबको अरेस्ट नहीं करवाइए.
My lord, I can submission, my lord. So my lord, I have objection, my lord, to that.
Oh, obviously, Mr.
Yes.
You will have objection.
Because my lord, there is a direct judgment on the line that if there is a 498A, my lord, acquittal, because
ठीक है. No problem. Rejoinder. Your instruction. You complete your instruction. And then say that. No?
4 weeks time for rejoinder.
To enable the 1 week. Enable the parties to complete their instructions based on dash.
Lords, in item 58, I am appearing for respondent number 1. Lords, I am requesting for a week's time to file my wakalat.
Power attorney.
Your Lordship, I am appearing for respondent state. Your Lordship, I seek time to file my reply and wakalatnama.
You are 2, 3, and 4, or
I am for R1, Lords.
I am for the respondent state of Chhattisgarh, Your Lordship.
enters appearance on 2, 3, and 4. Number 1, counter 2 weeks, rejoinder 1 week.
Interim order to continue.
Deeply obliged.
Lordship, interim order to continue.
Interim to continue.
Lord, 59, my lord had kept it today for hearing. So this is the matter where written submissions were filed in terms of 21st July order. Last time you'd kept it, my lord had kept it, but I understand this is special bench at 2.
Now, only thing is that that bench has also changed now. So therefore, this bench will hear it or should.
Lord, may I make a request? Lord, let this bench continue. We have no difficulty, Lord. Let this bench hear it. I have no problem, whichever way your lordship.
But today it can't be heard because.
But then 15th or 16th, Lord, if my lord may just keep it. 15th, if my lord, because there's an urgency. We have an urgency in the matter. Because my lord, I checked the orders. I thought it had to go, but it was not treated as part heard. Had it been treated as part heard, there was no question.
15 के लिए रखिए. 15 what date is it?
15th is Monday, Lord. Monday 2 p.m. Lord, if possible. Tuesday, Lord. Would your lordship fix the time because this will.
Time will come at 2 o'clock. I mean, we are here on.
No, Lord. Sometimes your lordship has a heavy board on Tuesday because of backlog. That's the reason.
We finish all our matters there.
I know. I just thought because this will take some time. We don't want to clog up.
Say hi.
I am on the board. 16.
Tuesday को क्या लगा?
16th.
We'll give you a day. We'll check up our.
Lord, I don't have. There is no interim order. And
we'll tell you 15th or 16th. We'll let you know.
Yes. Great. Let me check.
Yesterday I was to be led by Mr. Diwan Millards, but I don't want to seek a passover now.
I told Mr. Diwan one thing. Post-retirement, he has to ensure my membership there. Anyhow.
The pleadings are complete. This has to be heard, Millards.
whatever date your lordship says, our difficulty is this, my lord, this boy who continued to enjoy the facilities today cannot even practice now for his golf, and he's a reasonably talented and well-recognized player. So all that, I'm not saying anything, I'm just saying, my lord, would your lordship just consider a short date? That's all that I'm saying.
But my intent I have made known to both of you. I only hope Mr. Paul would request Mr. Dave and persuade my case.
Spare copy for R2 and 3. This notice has not been sent.
Oh, yeah.
That's actually office bearers of the club. I think.
No, but then does he accept them or not?
Because I'll file a vakalatnama for them. They're performer respondents, office bearers of the club, who were impeded at the High Court. So someone will file a vakalatama for them as well. There's no contest as far as they are concerned.
But someone has to.
I'll have that.
What date did? Shorty date.
When some Tuesday will not
Well, let it come on a Monday or a Friday if your lordship still feels, then because the point is short, that if a biological child is not the only category, can a ward not be entitled to the benefits? That's the short question on the reading of the articles of association. Grateful, madam.
Thank you.
Wait, please, your lordship. No, my lord, the marriage takes place in 2017. 2021, my lord.
A bail.
Lordship, a grand interim bail.
A bail we have said.
Yes.
It's an item 62.
Normally, it is the wife who commits this.
Yes, my lord. It is
the husband who is committed. Mr. Diwan, we kept it for some Monday or Tuesday.
Yes.
Well, item 62, because the High Court has doubled the interim maintenance primarily on my non-appearance.
No, it's 10,000 rupees, 20,000 rupees.
Let me see, the address she has given is where she resides. Well, let me see the memo 48, page 101.
Ready for settlement.
Well, we are ready for settlement also.
Let the order be complied with.
With
the possibility of settlement notice. In the meanwhile,
I'll keep paying maintenance as per the
you have to pay the amount, sir.
I'll keep paying as per the trial court order.
You have to pay the amount. Or you deposit here.
I'll deposit here.
Petitioner, subject to the petitioner depositing the amount as awarded by the High Court. Enhanced amount as awarded by the High Court. In the registry of this court, 4 hafte mein, and 2 hafte mein, and explore possibilities. Fixed by the trial court shall continue to be remitted.
I'm still paying that amount.
Remitted to the respondent wife. Next.
In this matter, respondent number 1 has completely ignored the provisions of section 41, 42 statutory provisions.
You are very good in law, very good case in law. लेकिन सवाल तो ये है कि what is your right?
No, that is okay that I have said, but they should follow the procedure, and High Court said it would be an empty formalities to follow the procedure. Now they will take the action today only. Bulldozers are present there.
Will it make any difference? Even if you are given this so-called notice?
No.
Procedural, okay, compliance, but then will it make any difference? Because.
अच्छा आप एक काम करिएगा, undertaking दे दीजिएगा, to vacate will protect you. खाली तो है.
We will reply to the show cause and we will vacate it when they will.
My lord has put a query to you.
Yes.
Would it make any difference is what we are asking.
We will get more time than that is.
So therefore you give the undertaking here, you will vacate. We'll give you time, no problem.
Okay, we will vacate.
How much time? 3 months?
6 months we will vacate.
Petitioners are ready to vacate the premises in their possession within a period of 4 months from today. Let notices be issued on this limited point. Petitioners shall ordered accordingly. petitioner shall file their personal undertaking indicating the area under their occupation, A, area under the, B, the name of the occupant, C, that they have not sublet the property, they have not allowed a third party to run their business from the same. D, the nature of the business they are carrying out. D, and the time frame within which they shall hand over. And that they shall hand over the vacant and peaceful possession of the premises to the authority within the aforesaid. Notice return, ये दो अगले हफ्ते ही दे दीजिएगा इसको खत्म करो.
Till the time, no coercive action, till that time.
Meanwhile, no course of action shall be taken.
My sincere apology, my lord, I was in traffic. I want 2 weeks time to file my wakalatnama as well as counter affidavit in this matter, my lord.
One week, response within 1 week, list on dash.
My lord, have it after 2 weeks because I have to.
2 weeks, list on dash.
Please oblige me.
Please, my lords. Nothing record from me, my lords.
Sorry?
Nothing record from me, my lords. I am jailed since last 9 months.
Notice.
Please.
इसी तो हो गया था ना कल के लिए वो साफ अच्छा she eaten something कुछ खाया she enjoyed did you take photographs
Now she's smiling, huh? No, all, huh? Very good.
ठीक है we this case we
my lord
साहब बात करके ऑर्डर लिखवा दूंगा साहब लिखवा देंगे ऑर्डर जो साहब लिखवा
my lord मैं
देखेंगे कल लगाना कब
my lord I'm sorry.
What have we done?
54, my lord.
What is that we have done?
Notice service is complete, my lord. Last date somebody is appeared.
No, we wanted because the amount is going to be enhanced substantially. So therefore, we said fresh notices.
May I serve on the standing council of National Insurance Company?
There's no standing council.
Good.
Chale.
Special bench 2
o'clock.
With the Lordship's permission. With the Lordship's permission, I mention item 31 for a second. In item 31, my lords, your lordships had passed an order asking the petitioner to deposit the entire arrears. I spoke to the client, lords, and that is around 11 lakhs, and he has only started working. Lords. Since there is a scope of mediation, my lords, I just wanted to humbly request if your lordships can ask him to deposit a token amount of, my lords, 1 to 2 lakhs, and he will start paying the arrears, the maintenance amount. At least the scope for mediation will be alive. That's my only request.
Need to mention tomorrow the bench combination.
Okay, so I'll mention tomorrow. Great.
वो लीजिए ना जिसके लिए रखा है उससे सिंबल कहाँ है? All that case first.
Item 303.
I'll call Mr. Simple.
Mr. Nair, you will have to wait, please. All matters will have to wait. Yes.
Plus, Mr. Simple is on his way. He was under the impression that 302 will be taken up first. The Lordship may have it after 5 minutes. He's on his way.
Okay. Till the time he comes.
He's saying you to wait.
Lordship's permission, my lord. My lord has permitted the application for substitution to be filed. It's allowed. We filed the amended memo of parties. My lords had directed us to consider an amount, my lords, of 25 lakhs. You know, we've gone back. My lord, there was a discussion. Subject to my lord's consideration, there's only one small request. They're willing to settle and close this issue, my lords, to other petitioner. If it may be considered that we may pay 20, my lords. There's no reason otherwise, my lords, only because, my lords, the allegations were serious. Otherwise, it's not a question of 5 lakhs. But what transpired and the reason, my lords, he was terminated, my lords, that leads to a certain situation within the company of other employees also seeing how such a matter has been dealt with. If my lord, subject to my lord's permission and consideration, if 20 lakhs may be considered.
Don't bargain with the court. We are happy to record with satisfaction. That the parties have amicably resolved their dispute on the following mutually equivalent terms. A. Impugned judgment and decree dated so and so as affirmed by so and so is quashed and set aside. We'll set aside that.
My lords, lordship may only
your benefit only.
No? My lords, it is the order is in my favor, my lords, because it is affirming an amount of rupees 5 lakhs.
So we are saying.
So lordship may only
whether it is 5 lakhs or 50 lakhs or 25 lakhs doesn't matter. The fact that you have been held, he has been held, his rights have been adjudicated in his favor is important. Why so is of importance. So therefore, we are saying that set aside the parties.
Lordships only request my lords 25 lakhs. Lordships may record as.
We are coming to that.
Only if it may be said that it may not operate as a precedent. My lords, I am only saying why, because there were other employees also who were terminated.
The parties. Towards full and final settlement of all claims of the petitioner, be it of whatever nature, the respondent has volunteered to pay a sum of rupees 25 lakhs on lump sum basis within a period of 2 weeks from today. This, of course, is in the peculiar facts and circumstances of the case, not to be treated as a binding precedent. The appeal stands disposed of the
Thank you, sir.
Thank you, sir.
Thank you, sir.
to my bank account.
The particular the bank account.
I already emailed it.
Shall be supplied by the petitioner to the learned counsel for the respondent for necessary.
Right. Thank you, sir. Thank you, Lordship.
Till the time Mr. Sybil comes, because we were waiting for Mr. Sybil, that's the really matter which we have kept. Anyhow, what is it?
No, isn't 303. No, this is an appeal matter. Parties. It's a renewal.
Can you just refresh us, please?
Yes, may I request you to just turn for a moment? There's a narrow issue which is involved over here in this case.
The only thing is, Mr. Devan,
Yeah.
Actually, we had kept this post-lunch session only for one matter.
I'm ready for that. Okay. May I then suggest, Your Lordship may keep it next week. Both sides have given notes. If Your Lordship sees them, Your Lordship's memory, will be completely revived. Because both my lords, had read it fully. These notes, 2-page notes will help you.
Honestly, today we have not even.
No problem. Your Lordship keep it. And they know the pressure. Whenever you
We had to see only that Mr. Devan was saying on the last date that there was some chamber note or something.
Chamber summons.
Chamber summons you have.
We were saying they are a party to the.
Chamber summons is an application. In Bombay, it's nothing but an application.
The order is to be passed on that chamber summons?
Yes, it was passed.
It was passed.
In our favor.
Common order. So, there is a common order.
The issue really is on maintainability of an appeal from.
Yes. Once you say that once you are deleted, you are not a party to the award, not.
Correct.
That's that case. That's that case.
It should not be a raid.
Yes.
Correct. And I have a very simple case, If I have filed a case against a party A, B, and C, and that case is dismissed, in appeal I have to carry the same memo or no?
No, but if he was allowed to be deleted by the chamber summons.
By the same order. By same order.
It's not the same.
Anyway, we'll place.
He says I should, it's very simple. You'll also be take it later. I have filed an appeal. He says I should not be made a respondent, right?
Just call 303 call.
If the appeal is allowed, we'll have to.
So grateful to my lord.
The Lordship is giving that. Yes.
Whenever.
What we are saying is, you please continue. So
Yes, may I just-
people is not standing outside.
May I just hand in, Manoj, that note which we give.
We've already filed.
No, Lord, I have not seen his note then.
No, we'll give it to them.
Keep it up then keep it next week. I have not even seen his note. You should have filed it.
Yeah, what we'll do is we'll keep it some other day.
Yeah.
Now, just as you were, now I'm fully into it now, but we'll have it some other day.
Yeah. Not any Monday.
So file it in court.
The Lordship will not be.
File it. File the sub.
Liberty to file note of submission. Or your Lordship will take it out high court.
Take it on.
Yes, great.
Let's give one to the.
I'll see it.
We have it.
Mission on behalf of
What is it? What is it? What do you mean?
22nd Friday.
Next Friday.
respondent with liberty to also file his name. You may also file.
We filed.
Is already. You may respond, sir, just in case.
I want to see what it is.
That's what we are saying.
Necessarily, I'll respond.
On to the need, should the need so arise. Then list on appointed legal.
Lord should consider 22nd minute so that we get some time to debate. Subject to Lordship pleasure. That will be a Monday, not Monday week.
इसको कुछ रखा तो नहीं है?
24 items.
19.
तो अभी 2 बजे के लिए ठीक. Just
yes.
We'll give you a date.
No problem.
Then we'll,
Any Monday or Friday. Whatever is convenient to you.
Monday or Friday, we'll just.
All right, fair enough. That will do. Keep your luck.
My lord, it's the third occasion we're waiting for Mr. Sibal.
So are we.
Our time is for my lords, but my lords are.
So are we. Yes, start.
Your Lordship, we filed the notes which were handed over on the last occasion.
Where is he, Mr. Sibal?
She's supplementing him.
He's on his legs, Your Lordship. He's on his way.
He's on his way. 15 minutes we have told that only. So you start now.
Chapter 1, Your Lordship, page 1 of the written submissions.
Submissions on behalf of the petitioner, West Bengal, correct?
Yes, Your Lordship.
Kunal Mimani,
He's the advocate on record, Your Lordship.
Okay.
Yes.
Yes. What's your good name?
Your Lordship, Mahima Cholera.
Mahima?
Cholera.
Are you with Mr. Sibal or are you with independently in this brief?
Independently with the law firm, Your Lordship.
Which law
Your Lordship, Fox and Mandal.
Okay. Yes, please proceed.
Yes, Your Lordship. Chapter 1. Whether in the Indian federal structure, each and every state in the country is constitutionally or even otherwise legally obliged to match rates of dearness allowance for corresponding periods as that fixed by the central government. Constitutional framework. The constitutional position in respect of aligning the payment of dearness allowance by the Union of India with the DA paid by any state government is the question for determination. It is a settled position of law that payment and the rate of payment of DA at the level of the central government is at its discretion, since workers to whom DA is to be paid needs to be cushioned because of the rate of inflation which is stipulated by the All India Consumer Price Index, hereinafter referred to as AICPI. This proposition applies to all employees of the central government. Entry 70 of List 1 of the 7th Schedule of the Constitution refers to Union Public Service Employees, All India Services, Union Public Service Commission.
This Mr. Sibal has already argued.
Yes, Your Lordship. So, Your Lordship, I can skip to para 7.
Yes.
A mandamus seeking DA at a rate that is separate from the notifications issued by the state is not available to the employees because they seek to demand more than what they are entitled to in law. Therefore, this honorable court has to decide the basic question whether on the basis of the notifications issued by the state government, it has committed to paying the DA with reference to the AICPI. It is submitted that there is nothing in the notifications to suggest the same. Your Lordship, the notifications mentioned here are the ones available at page 168 on.
Yes.
The AICPI only stipulates the rise in the rate of inflation on a monthly basis, which is taken into consideration by the central government on the basis of the explicit recommendations of the 6th Pay Commission to fix the rate of DA. That is the exclusive right of the central government.
Mr. Ahmadi, she is doing a very good job.
Yes.
Yes, continue.
If the central government were to issue a circular that all payments by the states of dearness allowance must mandatorily conform to the AICPI, such a circular would be per se unconstitutional. Therefore, no court can issue a mandamus for calculating the rate of DA on the basis of the calculation reflected in the AICPI unless the state governments explicitly state so in their notifications. In our case, Your Lordship, our notification does not have such a statement. The intent of the state government of West Bengal in issuing the notifications is reflected from the contents of such notifications, by which it fixed its own rate of DA. It is submitted that the state government had no intention of following the central rate of DA, and hence the notifications themselves issued from time to time have no reference to it. Hence, the state government has demonstrated its intent that there was no commitment to follow the AICPI. On the other hand, there is no challenge to the different notifications containing the rates of DA declared by the state from time to time in any of the courts below, and neither have they been set aside either by the tribunal or the High Court.
Yes.
The attempt of the respondents is to suggest through a process of interpretation that even though there is no explicit commitment, in fact, the intention is to the contrary. In the various memorandums, the Honorable Court must read into it a commitment on the basis that the whole purpose of the AICPI is to protect the salary of the employees and to cushion them on the basis of inflation. What the law does not permit directly cannot be done indirectly. The rate at which the DA is to be given by the state government is based on several factors, including its fiscal position, priorities, and capacities, which differ from state to state. The employees of the state government, in fact, have been given benefits which employees of the central government are not given. Your Lordship may note that details of these benefits are at paragraph 11 and 12 of our application.
Yes.
All these factors have to be considered, which are to be determined by the state government. Hence, a proposition of law that leaves no discretion in the hands of the state government would fall foul of the constitutional scheme. The Parliament or Union Executive may legislate or issue executive directions on matters within the exclusive domain of the state legislature or executive under Article 252 and 73 only, with consent of the state concerned, not unilaterally.
Correct.
Accordingly, imposing the AICPI, published and revised under the Union Ministry of Labour and Employment, for determining dearness allowance payable by state to its employees without such consent encroaches upon the exclusive domain of the state and is therefore unconstitutional.
Very good.
It would, in essence, amount to an abdication by the state of West Bengal of its legislative and executive functions in perpetuity in respect of subject matters over which it possesses exclusive domain. By mechanical linking of the rates of DA to the AICPI, which is published by the Ministry of Labour, Employment, Government of India, the state would divest itself of all control and discretion in fixation of dearness allowance and would instead be irreversibly bound by the AICPI as and when published by the ministry.
Yes.
Your Lordship, if Mr. Ahmadi...
Mr. Ahmadi already concluded. You are arguing so well, you're getting an opportunity. Please proceed.
And we may not allow Mr. Sibal to argue him. If we have already completed, because we had thought of allowing 15 minutes to each.
Yes, sir.
So that we conclude today.
Yes, sir.
We will finish. After. This is repetition of the same thing.
Yes, we'll not be placing. Supreme Court issue.
The young council getting
I place it.
We are
on the
court is allowing.
Place it.
We also see. My lord has already said it was Mr. Sibal was not here. We had only one option. Thank you very much. Young council, we are just waiting.
Yes,
My lord has clarified. If Mr. Sibal comes, he will only sit beside her.
And she is doing so well, let her place it. I don't mind, I'm happy.
Mr. Sibal has to share today's whatever.
Supreme Court's view on the issue.
Yes.
Para 15. This issue has already been settled once by this court in the case of Tamil Nadu Electricity Board. It's part of the compilation of judgments which we had
seen. That we have seen.
Yes.
Yes.
Similarly, Para 16 also refers to 3 judgments which are part of the compilation. Yes. 100% inflation neutralization, para 17, the dearness allowance calculated by the central government is 100% neutralization of inflation. However, we submit that there is no mandate to do so by the state and neither is it advisable as has been settled by the Supreme Court. In the case of Kamani metals, Your Lordship,
Yes.
it can also not be said that if 100% inflation is not being neutralized, such action is arbitrary. Thus, partial neutralization of inflation by the state while fixing dearness allowance after taking into account various other factors is non-arbitrary exercise of discretion.
Very well.
Your Lordship, if we may turn to para 22 at page 9.
Yes.
We have listed 12 states apart from the state of West Bengal.
Who do not follow central government rules.
Yes, Your Lordship.
Correct.
And a table is also provided at Appendix 1.
Yes, very well.
Your Lordship, at page 10, there are two tables which we have summarized for your convenience. The first table deals with 4 states being Chhattisgarh, Himachal, Meghalaya and Sikkim,
Yes.
which have pari-materia rule regarding the definition of existing emoluments.
Yes.
In the event, yes, if I may also read the definition for Chhattisgarh, 3E, which is the relevant rule for Chhattisgarh, means the sum of existing basic pay and existing dearness allowance at index average as on 1st day of January 2016.
Yes.
Similarly, Himachal Pradesh, existing emoluments means dearness basic pay plus dearness allowance appropriate to basic pay admissible at AICPI average of 1510 because the scale referred there is
What
90.
is the language in other states?
Yes.
These 4 states are in
These 4 states, Your Lordship, are
other states.
Other states, Your Lordship.
Granting on central basis.
The ones which are granting on central government. Your Lordship, we will have to check that once. But they are definitely not in, we'll have to check that, Your Lordship. We can...
the language is the same there also. Then what happens?
Yes, Your Lordship. So, the language in the rules...
Is there any judgment of Supreme Court which deals with these AICPI issues?
AICPI issue. So, Your Lordship, there are judgments which deal with neutralization of inflation for the purpose of calculating dearness allowance and salary, which is Kamani metals. We will have to check whether there's anything specific to AICPI index.
Because we are specific on AICPI.
Yes, Your Lordship.
This whole litigation is about AICPI.
Yes, Your Lordship.
Is there any judgment of Supreme Court which deals with this, whether this index average should be read on the basis of AICPI or your own state's understanding of index average or inflation?
So, Your Lordship, the with respect to your second query, state's discretion has been upheld. Yes.
For all the states.
Yes, Your Lordship.
It seems.
Yes, Your Lordship.
Will not decide, but the law will be applicable.
Absolutely, Your Lordship.
So today you are West Bengal. Tomorrow some other states say we have evolved our own index average methodology, which is still less than what you are granting.
Yes, Your Lordship.
Or more.
And with respect to your query on states' discretion being upheld for dearness allowance, the Tamil Nadu judgment has clarified that, but we'll check regarding AIC. Page 15.
Page 6.
Your Lordship, if I may just read the excerpt from the Tamil Nadu judgment at para 15, page 6. There is no rule or obligation on the state government to always adopt the dearness allowance as revised by the central government. Your Lordship, this itself clarifies and settles the issue that there is no obligation on the state to follow the AICPI because it is a admitted position that the central government follows the AICPI. It is absolutely not necessary for the state government to adopt the dearness allowance rates fixed by the central government. It should be looked from the financial position of the state to adopt its own rates or revised rates of dearness allowance.
Yes.
Your Lordship, if I may now place the table which starts at page 12.
Yes.
So, Your Lordship, the first table essentially set out those states where the definition of existing emoluments was similar, and our submission to that regard is that in the event this court is inclined to hold that there is an inbuilt in ROPA 2009 an implicit formula for increasing DA rates linked to AICPI basis this definition, these 4 states will get affected.
Correct.
And similarly, Your Lordship, the second table, in the event we are to leave aside this definition, and this honorable court holds that even without an explicit and implicit formula in the relevant ROPA, the basis or discretion of the state government to fix the rates of DA for its own employees should only be guided by and or 100% linked to the sliding AICPI index, which is the central government rate, without any discretion of the states. The following additional 7 states which do not follow the central DA rates also get adversely affected.
Yes.
Your Lordship, the factual matrix has already been placed by Mr. Diwan.
Now kindly come to page 40, the factual clarification.
Yes, Your Lordship. Your Lordship, these factual clarifications were placed by Mr. Diwan in his rejoinder.
That's right.
Yes.
And therefore, you kindly come to 43 additional points.
Yes, Your Lordship. That's
43.
Yes, Your Lordship.
Additional points.
Para 70. The upshot of the submissions of the respondents has been that it is explicit, if not at least implicit from ROPA 2009, that state of West Bengal is obliged legally to follow the AICPI published from time to time while declaring rates of DA. This argument is, however, belied from the tribunal's order itself, which you may kindly see at para 33 and 37 at volume 2, page 484.
Yes.
That it is the bounden duty of the state government to evolve norms, principles for payment of DA to its employees by calculating the same on the basis of AICPI published from time to time. It was on this basis that the Chief Secretary of the state was directed to evolve norms and principles.
That we have seen now. Delay and latches, what do you say?
Your Lordship, the period that we are concerned with is between April 2008 to December 2019.
If it is in their right and entitlement, suppose, then where is the question of delay and latches?
Yes, Your Lordship. If there is a question of right and entitlement, there is the only reason we've included this point is to describe the unreasonable time that they took to approach the court.
Thank you. So that's it. Thank you very much.
Grateful, Your Lordship.
So this side is over now. Please.
My lords, will restrict our submissions to.
We'll request you. Kagaz dijiyega, madam. We'll just request you. True to her word, she's not taking more than 15 minutes.
Yes.
If in 10 minutes each one of you wish to conclude.
We don't need long.
Just one thing. The AICPI aspect is dealt with us from page 35. Your Lordships have seen.
We have seen. We have seen that. Is there anything? See, what is it new that they have argued for you to rejoin?
Yes, sir. That's what we have restricted our submissions to. Please just hand over the short note.
We'll speak in 5 minutes because
we'll keep it short.
You are arguing to the rejoinder.
Yes.
Responding to the rejoinder.
See, what we'll do is, we'll go through your submissions. Rest assured, we'll go through the submissions of every word written there.
Don't read the submission.
If there's anything you wish to add orally, please do that. Otherwise,
My lords, I'll add orally, but I'll only take my lords to the parts that are directly.
We'll go through it.
Yes. My lords, Mr. Diwan argued first, in the first round, that the citation of the AICPI in ROPA 2009 was static. What does that mean? That leads us, my lords, to the somewhat absurd conclusion that the citation of AICPI 536 with reference to the series that 1982 is equal to 100 is only true for what they call the existing emoluments, that is 1 month. 1 month. So it would lead us to the conclusion that that index is only applicable for the month in which the ROPA rules were passed, and then that's it. Having our arguments having come in counter, my friends then argued, my learned friends then argued, I think it was Mr. Divan, that no, now it is a hybrid. So they said that there is that static AICPI, but then after that, there are memoranda that come in, if my lords recall, where the state of West Bengal exercises its discretion in the memorandum. My lords, if I may ask, is that a fair encapsulation of the argument? I'm grateful.
No, we are not saying anything. So we are not saying anything.
My lords, the difficulty is this, that the Constitution doesn't allow it. Article 309 is perfectly crystal clear. And what Article 309 says, and only for this purpose, if I may refer to para 2 of my submissions. It states that absent an act of the state legislature, the recruitment and conditions of service of a person serving the union or the state shall be in the competence of the governor of the state or such person as he may direct in connection with the affairs of the state, and I quote, to make rules regulating the recruitment and the conditions of service of persons appointed to such services in force until provision in that behalf is made by or under an act of the appropriate legislature under this article, and any rules so made shall have effect subject to the provisions of any such act.
No, we'll request you not to read, please. You just highlight the new points which you wish.
So this is the point.
What you have said that there was a dramatic shift in the argument. We have taken note of that. That it is static or non-static is one thing which you say. To what is your response to that? It is static or non-static?
My lords, the point that I am making is that the rules have to have a complete answer.
Okay.
That you can't have the conditions of service regulated in the memoranda, because what the Constitution says in Article 309, that you must have it either the conditions of service, including DA. No, it's nobody's case that DA is not a condition of service. So therefore, such conditions of service must either be in the act of a legislature or it must be in a rule.
So therefore, what you're saying is it is there in the act and the rule itself and not the memorandum. That's simple as that.
It's as simple as that.
Point well taken, ma'am. What else?
My lords, this I need not go into because my lords are well aware of these judgments. That rules override memoranda. You have Ajay Kumar Das, you have Ashokram versus the state of Maharashtra, you have Bank of Baroda versus Palani, you have, so this is all established. And my lords, when I say that the state has made dramatic shifts in arguments, I don't say this on the basis of just this hearing. I say this on the basis of a litigation that has carried on for 20 years.
Correct.
To the Advocate General, for example, the learned Advocate General of the state of West Bengal had said that it is ad hoc. That it is being decided in an ad hoc way, yes, but it is because we are deciding it on the basis of the funds we have.
Very well.
Financial consideration, paucity of funds. Again, my lords have on a number of occasions said that paucity of funds is no excuse.
The right is there, it has to be, it's complete.
Precisely. Now, my lords, the statutory scheme in ROPA I have set out in the third part. And the reason I have set it out
Yes.
is because there will be an attempt to say to my lords that this is a very big, matter. It has pan-India applications, etc. My lords,
It's a big matter, therefore you are appearing.
if only appear on sorts of matters. At this stage, my lords, the thing is that any decision of my lords has pan-India applications. This particular matter is restricted to this particular rule and the manner in which it is phrased.
Very well. Very well.
Now, what my young learned friend had just argued, and in fact, some people before her had also argued, I believe Mr. Diwan had also argued it. They said that, look, we cannot follow the central government rules. This is not something that's binding on us. That we cannot make good 100% of the inflation that is occurring. Now, my lords, with the greatest respect, this is a straw man. This is an argument that is not in the room. A bit like my learned senior Mr. Sibyl. Nobody has made the argument that we should follow the central government rule. We are saying that the state of West Bengal, having enacted the rule, which happens to be identical to the central government rule, identical in its phrasing, in its reference to the ICPI, that they must follow that rule. You've made the rule, you follow that rule. So therefore, my part 4 refers to the state is arbitrarily
That we have seen 1, 2, 3, 4 parts very beautifully. Now you can come to your part 5, please. Part 5 says that they themselves are following AICP, so therefore they are bound to follow it. That's it.
My lords, what I am demonstrating here is that they had consistently, until 2010, explicitly exercised their own constitutional jurisdiction to adopt and follow the central government.
So therefore, your right emanates from this.
So therefore, the fact that they then started following, citing the central government race, that's where my right emanates from, the 2009 rules. The arbitrary manner in which they suddenly said that this memoranda now occupies the field is something that doesn't even go with their earlier practice.
But then you have not answered that you have not challenged the memoranda.
My lords, with the greatest respect, the memoranda argument was made for the first time in this court after everything was filed. And I have set out what the state had argued before the tribunal.
Have your breath, Mr. Sibbal, don't worry. Have your breath, have your breath. Sorry. No, Prophet. Yes.
My lords, before the tribunal, before the High Court in 2018, where the High Court said that due to the fact that the state government has adopted the 2009 rules, that it is now a legal right, and that matter, if I may, that principle, if I may again remind my lords, is now raised judicata. It was decided in 2018. So now to say, having argued throughout paucity of funds, financial incapacity, we have discretion, to now say that there are all these memorandas that actually have the answer, and that create some kind of valid legal right, having not, my lords, challenged the 2018 judgment. Now, after all these years, my lords, just to refer very briefly to my earlier submissions, that perhaps...
You need not refer to that. We've already heard your list.
But to wrap up...
Don't worry. We'll go through it. Every letter which is written there, we'll read. Don't worry.
My lords, Kerala's example is illuminating. Why? Because there are many other states that some of which follow the AICPI, some of which don't. But for example, you have the state of Kerala. They do not follow the AICPI. They have their own consumer price index. And they have exercised their discretion under 309 by enacting rules that have a basis in Article 14. Having adopted the rules pursuant to Article 309, it does not lie with the state of West Bengal at all. To say that now we are passing memoranda on the basis of our whims and fancies, which now give us the right to take away your vested rights.
Very good. Thank you.
I'm so grateful.
Anyone else this side? Yes, Mr. Bhattacharya.
The basic issue is very simple. This is no question.
Just one.
Sorry, if you can sit here. Sorry. Yeah. I'm sorry, I didn't. The SIR matter was on, I was on my legs.
No problem. No problem. Instructing police has done brilliant. We have gone through your submission, which you have given.
Yes.
All of them.
Yes.
Mr. Ahmadi was all, and the other team, your team was there.
Right.
Should you wish to add anything?
Just 5 minutes.
No problem. We'll give you 5 minutes.
Just 5 minutes, not more than that. Because your lordship knows, the domain and the jurisdictions are entirely different. Your lordships have seen that. The entries are different, domains are different. They can deal with their employees, we can deal with our employees. Right? So that's one part of it. Two, if they were to pass a law saying accept the DNS allowance as discovered by us, it would be unconstitutional because that would be encroaching upon us. Right? So their entitlement is valid, but entitlement qua our notification. No doubt. They can't ask for beyond the notification. Now they are interpreting the notification in a manner to suggest that we have accepted the DNS allowance as well as decided by the central government. That's the thing. But our intention, we have reflected on affidavit that that's not what we want. Whereas our intention cannot be interpreted through a judicial decision making. No, this was not your intention. When we are saying it was our intention, and we have demonstrated that, then its impact on states. This is not a matter that will be decided by us. Existing emoluments is defined in several states where they are giving much less, including Himachal and other states, right? And those who are not defining existing emoluments, even they are giving less. So any decision by your lordships that what is decided in terms of the DNS allowance will apply to all states will have impact throughout, So therefore, it is my humble request, if your lordships are even inclined to do that, then your lordships must issue notice to all states, because then it can't possibly be that we are forced to accept DA decided by the union government, as well as the rest of the states, will not have to follow that. That's number one. The second argument is, your lordship knows that the genesis of this is under the industrial law. What used to happen was that an industry would have 3-4 regional offices, North India, South India, Western India. And the argument dispute used to be raised as to whether this DNS allowance should apply to other regions at all. And your lordships have said that DA is to be decided region by region. Why? Nature of inflation is different. Nature of the habits are different. Cost of living is different. What profits that particular unit makes in Ranchi would be different from the profit he makes somewhere else. So therefore, that has to be decided on region by region basis. Cost of living, purchasing power of the individual, what other benefits those people get, workers get apart from this, which are not given by the central government. So there is it's not just finance, there is a complexity of issues, So please leave it to the state government. Don't, go by this, that because the existing emoluments were decided there had to be a base year, and therefore everything that is said by the central government must be applied to us. That's all we do. I'm sorry,
Deepest of respect,
Just 1 minute. My learned friend relied on Article 309 so as to suggest in a manner of speaking that if there is any kind of a vacuum in terms of the rules, then that will have to be decided by the governor under 309. What I wish to point out is your lordships are aware of Article 162, where the executive power of the government is coexisting with the legislative power. So if today you have the legislative power under 162, you can always issue a notification
unless, my lords, it violates the statute. And it's no one's case that the notifications violate the statutes, the notifications are not undercharged. The other aspect that is sought to be urged willy-nilly is that we were earlier following central government's rates. That nothing can be further from the truth. Up to 2010, the rates that were adopted, let's say, suppose the central government had a particular rate in 2006, I adopted that in 2009. I have never followed central government. So therefore, my lords, those instances we can give a note also clarifying that. We've clarified that earlier in our pleading, that we have never followed central government.
That all clarifications are made, that 3 review petitions are taken from different time to time. But the issue is not that the center is directing.
How much time it will take, sir?
Well, I just finished within 10 minutes.
Thank you.
The issue is the entitlement of DA in terms of the statutory rules of the particular state. That the rules of state of West Bengal is not going to govern the state of Chhattisgarh. These are all wrong conception. Now, all these issues were considered by the tribunal. Kindly will not come to page 482, paragraph 30. What is the defense of the state? The rule makers have understood the rules in a particular way and they have followed it till 2010. Now, suddenly after 2010, they wanted to divert. Whether the diversion was at all reasonable according to rules and according to the state government's attitude towards the employees. And kindly, when I just read out paragraph 30 of the judgment of the tribunal, it was upheld by the division bench. On review, that was also again without upheld. Here, Malad says what norms, principles have been followed by the state government for release of DA for its employees. No satisfactory answer in this regard came from Mr. Basu, learned counsel representing the state respondents. Mr. Basu has merely tried to impress upon us that the state government has followed the pattern of central government in releasing DA to its employees. But the state government could not pay DA at the rate and from the date paid by the central government to its employees due to lack of financial resources of state government. This is the stand. Rule makers appreciated how the rule is to be interpreted. They were not by the brilliance of the councils. And then the tribunal says, we do not say that you have to follow the central government. We say you follow your own rules and formulate accordingly. Let kindly come to now paragraph 31. We have already observed that the payment.
Read, Mr.
I did not read. I just.
Give your submissions that what you are saying.
I say that
is there something new which you wish to add?
Nothing. I no substantial legal argument has been advanced by subsequent attempt. This is repetition of the old things. And they have to follow their own rules. Tribunal has directed the chief secretary, you formulate. But why didn't they formulate? So these are the simple.
Thank you. Anyone else this side? Thank you.
Sir, I'm just stepping into the shoes of Mr. Gopal Subramanian. The written submissions on his behalf are there. I'll just hand it over. And additionally, there are some rules that we wish to place. There are copies of the rules that we would like to show. Just one submission that I'm not reading out anything. Just one submission that the entitlement flows from the service rules that the employees have. And the entitlement rules, entitlement is under the West Bengal service rules of 1971. That compilation of rules we have provided. Rule 93 of the service rules indicate.
Our request to all of you is whatever you are handing us to in court, you have to e-file it, please.
Please, we'll be e-filing it and as well as with physical copies. With the registry, we'll ensure that.
Please.
So it's there on my lordship's file.
Yes.
May I go back to what that is Parthur's?
One more, sir. Pleasure, please.
Sorry.
Yes.
Rule 93 of the compilation rules, the rules which we have brought out.
Where is it? Which page?
Yes, this is page 74, internal at the bottom, page 70.
We don't have that.
We'll just give it. May I have page 74 flagged at the top.
Yes.
74. Rule 93, Mulus. A government employee shall be entitled to be paid while on joining time, Mulus. Clause A. Under Clause A of Rule 50, the pay which would have earned had he not been transferred, he will also be entitled to dearness allowance, if any, appropriate to the joining time pay.
This is my entitlement.
So, Mulus, the rules itself provide my entitlement, that I am entitled to the rules, I am entitled to the dearness allowance. And it is not the memorandums. That is what we would like to clarify, Mulus. And the rules having been accepted, Mulus, in 2006, Mulus, 1/1/2006 date has been triggered off, on which date, Mulus, AICPI has been accepted. Yes. Now, Mulus, the rules clearly say that the formula which is there, Mulus, your lordships have seen that, page 103, Mulus, AICPI formula has been brought out. Therefore, Mulus, it is implied and very clear that it will be the formula as per the AICPI. Now, Mulus, that formula, Mulus, cannot be static. It has to change, Mulus.
Now, where are you reading the formula?
Mulus, in the paper book, Mulus. 103 of the paper book, your lordships have seen the ROPA rules, Mulus. Existing annulment, Mulus. From here, Mulus, I was only indicating page 74. The lordships have marked. This is Rule 93, Mulus.
Okay.
On the basis of Rule 93, Mulus, I am only indicating that the service rule provides that I am entitled to dearness. 103 Mulus of the ROPA rules talks of AICPI, Mulus, the formula which is there, and it is not a static one, Mulus. Therefore, with Mulus changing times, Mulus, the formula will have to be applied. On the day, Mulus, it was applied. The emoluments that and the salaries that we were getting, Mulus, were at par, and therefore it was at zero level, Mulus. And thereafter, Mulus, it has kept on increasing, and therefore the formula will have to apply with time, Mulus. It cannot remain a fixed thing, Mulus. So that is the broad, Mulus. Otherwise, Mulus, we've given the written submissions, Mulus.
Only one point I need to address in rejoinder. Mr. Diwan actually gave a rejoinder note, which is a note common to everybody, or it is only for Mr. Diwan, Manoj. Two things which he primarily said was that no mandamus can be issued unless there is an entitlement and public duty is one. Second, what my learned friend just preceding me also wanted to impress. He said that these ROPA rules only provide a statutory framework for revision of pay structure. It does not create any entitlement for payment of any allowance, let alone DA, and it cannot be pegged to an index. This is what they are saying, that it was a one time and there is no question of any index. However, there is a very fundamental flaw in this. In the first round, your lordship is aware that this is the second round. The tribunal first held against us. We went to the High Court.
Yes, please.
In the first round, at page 375, that is the judgment, that is the relevant part of the judgment, which is rendered by the High Court in the first round, against which they filed a review. Review got rejected. There was no appeal. Your lordship may only note page 374, para 75, para 24. I will read to your lordships. In fact, if your lordship has the second volume, precisely the same argument raised by the learned Advocate General and rejected.
In the first round.
Correct.
We are aware of it.
Then it says, apart from the fact that
we have heard it. We have heard it.
Yes, your lordship is aware. It says, Mr. Kishore Datta, learned Advocate General, according to him, the findings of the tribunal that the claim of dearness allowance was not based on any legally enforceable right. According to him, the pre-revised scale of pay of the government employees has been transformed into band scale. According to the learned Advocate General, after initial fixation of pay under the ROPA rule, no formula exists for fixation of payment for the subsequent period. So what he said was, rule only, what Mr. Diwan also argued, was one-time fixation. There is no question of any further revision. This argument is considered in great detail. I had referred to that judgment. how does the consideration starts first by noticing the relationship between the employees, then noticing the concept of what dearness allowance is.
We appreciate that. Mr. Patwalia, can we just request one thing? Other than this, anything which you wish to add?
No, other than this, Manoj, what I wish to say is that in the initial written argument which they filed,
in fact, what we are going to suggest to each one of you is this, that there are so many,
we should consolidate because while writing judgment, your lordship will need that also.
Comprehensive submissions first to be filed by the petitioners and then to be responded by the respondents.
Yes. Let us give a final submission of what we are saying in one.
That's what we
can.
So you will file it in how much time? That's all, Mr. Patwalia?
There is nothing much, Lord. Your lordship have heard it for so long now. If I say something,
how much time?
Well, only one point I have been asked repeated and validly so. In the opening submissions which they gave, Lord, State of West Bengal, they gave a common submission. Now there, and we have revised the CPI index. Now their written submission has turned on the head.
It's all right. What we'll do is, whatever they want to say, whatever doesn't matter. Let them. We can't stop them from saying they have right to say also. Mr. Singhvi, would you like to also address us on this issue? Yes, Mr. Singhvi. Please unmute him.
No, Malas, I think, Malas, we have taken enough time for lordships.
Thank you.
Covered most of the points. I don't want to add to that. Otherwise.
And your lordships have noted his presence, which is most important.
As if it's not important for Mr. Patwalia.
We are today only to say nothing more to be said.
We have heard. Thank you. We have heard Mr. Sibbal, Mr. Singhvi, Mr. Ahmadi. I'm sorry, ma'am. What's your good name? Just give it writing so that I don't commit a mistake. Add her name also. As also for the on behalf of the petitioner, also Ms. Karuna, Ms. Patwalia, the respondents. Judgment reserved. We request the petitioners to file comprehensive. It is suggested on behalf of the Learned Council that let the parties file comprehensive written submissions. We agree with the same. Let the petitioners file written submissions comprehensive in nature, dealing with all aspects argued before us within a period of
by next month.
Whatever it is.
Do it within whatever time.
2 weeks. 2 weeks. The respondents respond to the same within a period of 2 weeks. 1 week. 1 week.
There are so many of us. Let there be 2 weeks if some intercede. All right, 1 week is also enough. 1 week is enough. 1 week is enough. 1 week is enough.
1 week.
Lords, one request and nothing new should be said now.
We are happy that the batch is completed.
Thank you. Thank you.
We're so grateful.
So he said you can submit rejoinder written submission.
Thank you. So very kind of you.
Deeply obliged. Deeply obliged.
Yes.